May I please, Your Lordship? My Lord, defect is I have filed this contempt. My Lord, there decree passed by the Lord district judge declaring my right title interest. I filed a mutation case. The Annex 3, though he admitted the Arishal Tahsildar that the right title interest of the it has been decided.
No notice is issued as it.
My Lord,
First time it has come.
First time it has come.
But issue notice.
Defect has
been removed.
Yes, the defect is that 9(2), as per it is stated that it cannot be filed directly, but it can under section 10, Your Lordship has ample power to
Keeping open the defect pointed out by the registry, issue emergent notice to police, emergent police notice.
So it can be ignored.
Let us see. After they come, that is it. It appears to be that way. Perhaps I am agreeable with you, but let us see what they will say.
Much obliged.
Yes.
Item 2.
My Lord, I am challenging is inaction of the OP number 2, my Lord. My Lord, who has not considered the letter submitted by OP number 4, my Lord. Though the
letter,
my Lord, under Annex 3, my Lord, in where the OP number 4 sought a permission for constitution of a governing body of the college.
you consider that, G?
My Lord, it is pending before opposite party number 2.
Short grievance of the petitioner is as to non-consideration of his representation dated.
Dated, my Lord, 5/3/2025.
That is regional directors for 5/3, we'll put that date, 5/3/2025. Wherein a prayer is made for constituting the governing body of Santa Kavi Bhima Bhoi Bhima plus 3 Mahavidyalaya it is. Mahavidyalaya Chakrakhand
District Bargad.
as per the Odisha Education Establishment, Recognition and Management of Private Colleges and Companies Rules 1991 as under date up to date in consultation with the President of the Educational Agency concerned. First, the counsel for the petitioner suggests that where a representation of the kind is made under the provisions of rules, it is the bounden duty of the officials to give take a decision thereon within a reasonable period, and that having not been done, interference of this court is warranted. First one. Next one. Learned AGA, Mr. G, on request accepting notice for the office, very fairly submits that they would instruct the OP number 2 to take a call in the matter if all contentions are kept open and a reasonable period is prescribed. First, this is really appreciable. First, next one, in the opposite 8 weeks. Open to solicit cost material or not written cost material yesterday, none of the orders. Yes.
My Lord, time may be fixed within a month.
8 weeks. 8 weeks.
Right.
Item 3.
Item 3, the claim of the petitioner has been rejected under Annex 11, my Lord, for payment of arrears salary from
Arrears of salary
my Lord. Annex 11.
from 1/12/2015 to
25.
10/4/25.
Yes.
Yes, also it is rejected.
On the ground that he was absent from that, but petitioner was working, man.
Petitioner was working.
Yes. Letter was issued to the petitioner for verification of certificate on 1/12/2015. From that date, the salary has not been paid. So in the 2025, after
Where is material to show that your evidence that you were working?
the certificate, my Lord, training course certificate, page 27.
Training course for 10 years.
10 years, but it is 2019. Working. So my instruction, he was working.
For instruction, all right. But can instruction take the place of evidence? You might have told so many things.
In that period, he has completed his training course, my Lord.
Notice. AG requested to accept notice for
for opposite parties.
One, all.
No, no, committee is not private.
Private managing committee.
One private.
1, 2, and 4.
Four.
Emergent notice 2, 3. Post immediately after service. Yes.
Item 4.
Well, this is a case of transfer. Your Lordship may kindly turn to Annexure 3.
Level 5D.
Yes,
Senior teacher.
24/9/2025, Annexure 3 at page 18. Pursuant to letter number such and such, dated such and such, of the District Education Officer Devgarh and being approved by the Collector and District Magistrate Devgarh, Sri Dileshwar Pradhan, Assistant Teacher, Government Upper Primary School, Tabada,
Yeah.
is hereby transferred and deemed to
For
be...
adjustment of single teacher school.
In order to accommodate Rasmita Maji, this has been done. My second ground is, I'm a kidney patient. And my wife is also serving in the same school.
No, that's all right.
But
Kidney
I have-
patient means,
My lord,
kidney patient means what is kidney patient? There are many.
he is under medication. He is under medication.
Many are under, even I am under medication.
But he is under medication. And another thing is,
No,
my lord,
very
he is
solution.
the prescription is 5, Annexure 5 series. Your Lordship may kindly see. He is also suffering from seizure disorder, neurological disorder, Annexure 5 series. And his wife is taking care of him.
You take wife also to that place.
My lord, but my wife is continuing in the same school.
He is working in same school.
Same school.
How many kilometers between these two?
My lord, this is 30 kilometers.
30 kilometers.
30
One
kilometers.
should travel.
But your Lordship may kindly see there is no communication facility. That is in a jungle area. Therefore, my entire endeavor is, I have made a representation to the director.
Okay.
Let the director consider it in any nearby school.
Petitioner is before this court, giving a non-consideration of his representation dated 25/9/2025, copy whereof avails at Annexure 6, wherein he has sought for cancellation of the transfer order dated
24 now.
transfer order evenly dated. First off, not let the counsel appearing for the petitioner submits that non-consideration of representation of the kind would give a cause of action in the light of professed petition in Varadhara versus State of Karnataka. And therefore, the OP should be mandamused to take a call on the same. First off. Mr. G, I will direct them to consider.
Let them consider, but that representation may be treated as an appeal. Because
Yes.
alternative remedy is
The
appeal.
instruction appeal is provided to
Appeal
the
is
director.
provided to the
That will be
director.
treated as appeal.
Learned AG and Mr. G, on request accepting notice for the official or the OPs, submits that the correct procedure for the petitioner is to take up the matter in appeal at the departmental level.
Director,
The director.
Director elementary.
Director.
More particularly to the Director of Elementary Education, and therefore petition may not be entertained in the absence of petitioner not availing. In the absence of petitioner
I have made a representation to the director.
availing the said remedy. First, however, he agrees with the suggestion of this court that the OP number
OP number 2.
OP number 2 shall treat the subject representation as an appeal, since there is no format prescribed
Yes.
for filing the appeals. First, he further submits that all contentions be kept open and a reasonable period be granted to process the representation in question. First one. With this proposal, counsel for the petitioner is also agreeable. Next one. In the above circumstances, petition is disposed of. First one. The representation shall be considered by the OP number 2 at the earliest necessary by giving an opportunity of hearing to substantiate the contentions taken up in the representation. First off, till such consideration takes place, have you been relieved now?
No, I have not been read.
The transfer order to be kept in abeyance only if petitioner has not yet been relieved of his duty at the present place.
Yes.
First, all contentions kept open. Item 5.
May I please?
Yeah.
The grievance of the petitioner is non-sanction of RSP, second and third RSP. Despite my, in view of the resolution dated 13/2/2025 annexed 5.
Have you given any representation?
Yes, my lord, I have given a representation, and when I wanted to know the reason, I was communicated, my lord may kindly see Annex 7, page 33.
What they say?
They say that.
You are not entitled to.
No. They say that region will be mitigated in a court of law. The region will not be communicated to you.
Why? Mr. G, what kind of orders are these?
So let them be directed to communicate with the region whether I am entitled or not.
Any official secrets act is involved. Unless reasons are given, how he will be able to challenge it? Or maybe to overcome that Mohinder Singh Gill, the validity of the order should be adjudged on the basis of the reasons given. Therefore, we will not give reason only. All contentions will be open to resist the petition.
But the 13/2025 resolution says.
You are entitled to.
No.
Huh.
My lord may see page 29. The resolution say wherever required in acceptance with the modified RSP benefit already sanctioned in favor of any service or retired or superannuated employee shall be revised by so and so. But the last line by vacancy.
Yes.
Irrespective of absence of the employee or had taken shelter of coastal law or not. So now they are to issue notice so that.
G itself.
My lord, let them directed to give the region first. No, let it be decided.
They will give reason and they will send you again for another.
They will give. I don't know the region, my lord. Yes, my lord. I am ready to take notice.
G,
All are government.
request accept notice for the office. All of this.
All are government.
Controller of accounts also.
Yes. I think
There is a separate matter lies in another compass, and it's a curious matter because the impugned order says no reasons will be assigned to the petitioner. First in the second week, third week of November. Yes. Item 6.
My lord, kindly pass over this matter.
What is this matter?
This matter is all, actually I don't have.
Permission for staging of
Opera, etc. Mahotsav committee. Governor 32 Western.
We held on 14/11. Mr. G, you accept notice.
My lord,
And I'll call it before 14 because it begins on 14.
Yes.
my lord, it will take long time to for preparation. So it will better if you take this matter today after lunch.
How? But he has to take
Time to get instruction from Bogre.
his official clients now.
Then
We call it next week.
next
It is
week,
on 14th. It begins on 14th.
it will take time to prepare for preparation. It's a,
But you have come very late.
no, we filed the petition, but it will
Yeah.
take.
I'll get instruction.
Notice will call this matter next week.
Next week, my lord, yes.
Yes.
Much obliged.
Call this matter next week. But he gives that date.
Monday, my lord.
First, in view of urgency, please. All on sides.
Much obliged.
Date is fixed to my lord.
Date is this. Which date? 6/11. 6/11.
10th, my lord.
10th, but 14th it will be.
Ma'am,
Sixth, my lord. Yes. Yes.
They can say no. We cannot say no. Yeah.
All right, my lord.
Correct?
Yes.
6 people. Yes.
much obliged.
Item 7? Yeah.
But the punishment order is under challenge. Two punishment has been imposed. One major punishment, withholding 2 increments with cumulative effect, and one minor punishment, censure. And here copy of the inquiry report has not been supplied to me. Second so-called notice was not issued to me.
Notice be issued.
Notice be issued.
G accepts notice. Yeah. Item 8.
Commit me, please.
The second show cause notification, you are
Well, that is contemplated under our rules.
no, Constitution has been
Constitution
amended.
Article
na?
311.
Yeah, 311 is amended.
Yes, amended.
So
But
dispensing second notice.
so far as CCA rules is concerned,
No,
how
I
CCA
don't think
rules?
that rule can run to contrary to
Yes,
the
yes.
Constitution. Anyway,
But I am conscious of that. My lord will pose that question to me. I am conscious of that.
Item number 8 is a rather info square. I had applied for building permission, Your Lordship, permission for grant of license to develop my land. There has been some dispute with the estate, the planning authorities. Lordship, Odisha Town Planning Improvement Trust Act provides under 33(4), I can make an application to the state in case of any dispute. I have made an application. It has to be routed through the director. Now the state has directed the SPA, the Special Planning Authority, Bhadrak, to dispose of my grievance.
even then they are not doing.
I just want a direction. Let them take a decision thereof.
Annexure 8 maybe.
Lordship.
And his prayer is also.
Yes.
Petition prayer reads as that. Petitioner attention to the court to his application dated
Lordship.
29/5/2025.
Lordship.
Filed under section 33(4) of the Odisha Town Planning and Improvement Trust Act 1956. Which is pending on the file of OP number 4, who is not taking the decision. First, the counsel for the petitioner submits that the application is made under a particular statute, it is the bounded duty of the statutory authority to take a call thereon. And that has not been done. This court should grant interference. Next. Learned AGA Mr. G very fairly agrees with the suggestion of this court that OP number 2, OP number 4,
OP2 is the authority, but he has marked the matter to the
Your Lordship may
Lordship.
form of an appeal.
correct. Appeal to the government.
Appeal to the government.
2 it is.
Then the government, the secretary, principal secretary,
He has
for the
marked
matter
file
to SPA, who is not the authority.
So government itself has to
Yes,
take the
yes.
decision.
OP1 is to consider Annexure 8.
Lordship.
Directing OP number 1 to consider Annexure
8, my lord.
And 9.
8.
9.
The same reminder.
Dated 29 to consider the subject application.
Lordship.
Appeal.
Appeal.
Yes.
Subject. He has said application. No?
It's in the nature of an
By
appeal.
treating it as an appeal
Lordship.
under the provisions of extant law. Or keeping open all contentions and prescribing a period of 8 weeks for disposal.
Lordship.
Ordered accordingly, WP disposal.
Grateful.
Item 9.
May I please, madam? Another addition, your lordship is hearing a bunch of matters. Is financial benefits under placement rules 2014, your lordship. It's final order, my lord. In this case, they have rejected.
Then let go decide.
Oh, yes.
Yes.
Same thing has happened in that.
Next.
Item 10.
Your Lordship may kindly adjourn this matter for tomorrow. The senior counsel is out of town.
This matters. Just tell.
Sir, in this matter, sir, the petitioner is seeking for an inter-district transfer. The place where her spouse is posted.
Have you made any representation?
Representation to the minister.
Representative to the minister
You
has
should make it to Director of Education, Elementary Education.
No, here it is at the Rural Development Department.
Appeal license under which?
Elementary.
Director of Elementary Education.
It is Rural Department.
Who are your OPs, brother?
Your Lordship.
Directorate of Secondary Education. You have been- Make a Director of Rural
Yes.
Elementary Education a part.
Yes.
We just amend. Petitioner is permitted to amend the description of OP number 2 as Director of Elementary
He
Education.
has made opposite party director secondary education.
No, therefore it should be Director of Elementary Education. High school.
High school.
Correct. High school.
Ah.
Is it high school?
Yes.
Then it should be-
Secondary. OP2.
Understood. Then yes. OP number 2 has to take the call.
Yes.
Yes,
We
Lord.
direct them to take the decision. And till decision is taken, there is against transfer, na?
He has to file fresh representation.
But he will do it. That will only lengthen the period. He will be in the same school again. It will defeat your purpose. Of course, I'll do that also. You file appeal before the Directorate of District Education Officer.
And minister on the body of the representation has forwarded to the director. That your lordship can. Yes, Annex 7 your lordship.
But who has to take the decision?
Director secondary education. 24 Annex 7 your lordship just have a glance.
Right. The short grievance of the petitioner is against the transfer order dated. Just look into it. Tell the date. So and so.
14/5/2025.
Copy of the education. Where is that copy? Annexer?
7 page 24.
At Annexer 7.
Recommended to the director. Minister has recommended to the director.
Counsel for the petitioner submits that already a representation is moved in the format of appeal before the jurisdictional OP, and that even the minister in charge has directed consideration of the same by forwarding it to the state authority
On 12/2025.
on 12/5/2020. 12/5/25. First one, he adds that under Article 350 of the Constitution of India, as extensively interpreted by various high courts in the country, a duty is cast on the jurisdictional authority to take a call of the representation whereby a citizen airs his grievance. First one. Next, learned AGA, like the appearing for the OPs, very fairly submits that he would instruct number two to look into the grievance of the petitioner as has been heard in the presentation, if all contentions are kept open, and a reasonable period is prescribed for doing undertaking the task. This is the petition. Next, in view of the above, 8 weeks. Already relieved or continuing?
No, sir, it is continuing.
Continuing. First. Till consideration of the representation takes place, petitioner shall not be relieved from the existing school unless he is already relieved.
Yes.
All contention kept open. Next.
Short pass.
That matter. Mandama city.
So it is a case I'm challenging the letter dated 23/9/2025, Your Lordship. They have issued a letter. The general manager of OMFED has issued a letter that to all the transporter has to follow the certain rules and regulations.
So take notice.
Yes, sir. But I have filed an IF for stay of that.
How can we grant the interim order? It will be giving a final order.
But in that agreement, there is no such terms and condition as that.
Supply of milk will be, though state, no relief has even assert for against the state.
2020.
Supply of milk will be stopped.
You
2023.
take notice.
And for OP1.
For consideration of interim order.
State is for OP1. The private
Issue emergent notice. Mr. Lenko accepts notice for OP number 1. Emergent notice to the rest. First one. Post this matter before the court.
We are having panel. I think Amit Patnaik.
It is open to the petitioner in addition to taking individual steps to solve
till that,
on the panel advocates, if any. You have to take steps, and in addition to that, you should do that.
Lordship, I have filed this stay of that letter.
That I will consider only after notice is served, not before that. Otherwise, it virtually amount to granting final. Otherwise, I would have granted. Was put before the court for consideration of interim application immediately after service. Next, item 12.
May I please, my lord? Lord, in this petition, the petitioner is seeking the financial benefits associated with the post of principal, your lordship.
At the 16/9/25.
My lord.
If that is considered already.
No. 16/9/25, they have taken a position that,
Saying?
these are not applicable to us.
File counter, man.
issue emergent notice, Lanka accept notice for the notice. Matter lies in an error number, therefore mostly in the last week of now.
Item 13.
Yeah, please, Your Lordship.
Proclamation is what?
Yes, proclamation. Verification of caste certificate, SLC, and a similar matter, my lord.
What we have done? Your alternative remedy?
Yes, good.
Yes,
That's
sir.
issued notice.
Was it being order or my?
This Your Lordship. Your Lordship, business. Your Lordship has issued notice.
Yes, issue emergent notice. The Lanka accepts notice for the OPs. The counsel for the petitioner presses the IA number so for protection, interim protection. First, he also draws attention of the court to the interim order dated 15/10/2025, whereby such protection has been accorded in WPC 28448 of 2025 between Susmita Behera versus State and others. First, a prima facie case is made out for granting protection. Then, next, in view of the above, the application having been favored, all further proceedings pursuant to subject proclamation are halted till the next date of the
Not under Annex 12, only in this case, the Annex 10.
Annex 10. Which will proclamation at the later.
Next item also, sir.
This matter along with the WP number. Which are the other matters?
Another next item.
Same order.
Same.
Annex
Exactly.
Same.
Same.
Not along.
Only this next item, only the Annex 9 is the challenge.
Sir.
Item 6 matter. Due to the rainfall, I am not coming in proper time.
It is disposed of, huh? Six.
Lordship directed me to get representation is pending. What happened, madam?
14th.
Yes, madam. What happened? That is the Jagannath committee. That organization performed the 32 base, 32 base of Jagannath. Lord Jagannath.
Yeah.
That is a culture continuing to every year's manner. But now our application is pending in Annex 4 before the sub-collector man. People Lordship directed and consider because pendle theory
Because they have to make preparation and other things.
Yes, madam.
Your Lordship
Directed me to get inter mega pattern will concentrate, madam. It will come.
Sure, madam.
Yes.
On 6th he is coming. Already I have made order of hearing. Even junior asked for time also. But I told him that because otherwise it will be it amounts to final order because he pressed for interim protection. But I said we will consider on 6th. Let it come on 6th.
In the meantime, instruction will take.
Yeah, in the meantime,
I'll get that.
One sentence you are there. The pendency of WP shall not come in the way of consideration of the representation dated.
Reference 17/9/2025.
Annex
4 series.
4 series. You take that all. Report
Item 15.
I mean, pardon, my lord. Item 14, my lord. That is the item 13 Annex 10 challenged. Item 14 Annex 9 challenged.
9 in the morning.
Published.
Cash proceedings.
Yes, ma'am.
No. Yes, Mr. Krishna.
May I please, Your Lordship? And this is challenging the inaction. The background is this, with Your Lordship's kind permission.
Allotment of plot number 38.
38. Mad one Kashinatha Panda, he was laid out.
We let notice go.
I'm only playing my 2018 it is pending.
Let's hear. 30A plot belongs to government. It was never leased out, nothing, my lord.
Just let me then clarify a little bit of fact.
But you are given the representation, na?
My lord,
Since
first appeal was carried, second appeal, Supreme Court. Then now representation.
That is a statement withholding certain facts. Let me clarify. And there are two plots, plots 30, 38.
Anyway, you take notice.
But
You accept notice.
I'll just clarify. Vis-a-vis.
Well, I am agreeable with you. Still you want to argue?
No, my lord. I'm saying let him take instruction. Since he is opposing, but the rejection will not help.
Issue notice. Mr. Behera already he accepts notice for the fee number. Both is. Okay.
With your lordship's signed permission, there has been one lapse for which I apologize. But I have not annexed a copy of the judgment of the Hon'Ble Apex Court.
Yes.
May I, with your lordship's
The memo you can.
Please give one to me.
Yes.
At the request.
So after my friend reads that order, he will agree that it is to be considered, not that I am just blank claim.
At the on the I will
Last paragraph.
senior executive minister has with the leave of the court placed on record along with the memo a copy of the judgment of the apex court, order of the apex court in judgment location. The same is taken on record.
I only pray, my lord, any reasonable sort that as your lordship's convenience. Convenience, fine.
The first week of January 2020.
But can it not in December?
2018 you have waited. How many years you have waited? And you have lost battle of Rome.
But now here, Honorable Supreme Court has said you apply, it will be considered. That was way back in 2018. May I pray December any day?
Third week of, second week of December.
I'm so grateful, man.
Yeah.
Item 16.
In this case, the legislature has been transferred twice within a month, 3 days. Her husband is a handicapped person. She takes care of him.
Transfer?
Yeah. Twice in a month.
Till 9:25. Whether she is relieved?
No.
Not yet relieved?
Yeah.
Brother Behera.
I have filed for stay.
Now they have filed, let them file the appeal.
Well,
And till a decision is taken on the appeal, don't disturb.
unless he is released.
Of course.
Well,
All right. You are agreeable with that proposal? Okay. Essential grievance of the petitioner is against the transfer order dated 10/9/2028, copy whereof 3, which reads as next one. Learned counsel for the petitioner submits that the transfer order is fraught with many illegalities and therefore the same is set aside. First one. When learned VGA Mr. Behera draws attention of the court to the alternate remedy available at the departmental level, counsel for the petitioner in all fairness submits that he claimed be permitted to make an appeal to the jurisdictional authority within a short period. Until then, interim protection may be granted. First, Mr. Behera opposes the petition. Next one. Having heard the counsel for the parties and having perused the petition paper, he is inclined to grant a limited indulgence in the matter, keeping in view the law declared by the apex court in Varadhara state of Karnataka, to the effect that petitioner should make appeal to the jurisdictional authority, that is OP number 3. Yeah. OP number 3. And against the transferring question within 2 weeks. And if appeal is made accordingly, the same shall be heard and decided.
my lord's director, appeal to director is not made a party.
Just only jurisdictional authority. That is director of which education? Is it high school or primary school?
School and mass education.
Director of elementary. Director of elementary education.
If there is private school teacher, then elementary.
He is primary school teacher. She is director of elementary education within 2 weeks. If the appeal is right, the same shall be heard and decided at the earliest. First time. till that exercise happens. Come on. The petitioner shall not be relieved from the present place. If already not relieved. Next one. Yes.
17. The petitioners were working as part-time physical education instructors.
Similar matter.
Yes, Your Lords.
What we have done?
My Lord has been placed to direct disposal of a representation. There it is Annexure 5. In our case, it's Annexure 6.
In the light of Jago,
Lordship.
Annexure 6.
Series Lordship.
Dated.
Lordship.
You just change that Annexure 6 and give the date.
Lordship. Lordship. Corrected. Yes, I also.
Item 18.
May I please?
Yeah.
Now, this is the fourth round of litigation for getting arrear salary from 7/6/1994 to 34/98. In the meantime, the petitioner who is was working as assistant teacher has also been retired, and
you take notice.
Mail.
That is the issue of budget notice, GXF notice for all of police. Short point is involved, and this is the fourth round of litigation. Therefore, post it in the first week of January 26.
blessed.
Item 19.
May it please, Your Lordship.
Yes.
Well, I am a contractual lecturer in Ravenshaw University. I filed this writ petition for regularization of my services. Well, it's this business administration discipline.
How many years you have been?
Well, I have been in service for more than 10 years. Now, this course was introduced by Ravenshaw University in 2008. And since 2008, they have been running the entire faculty only through contractual faculty. Well, Mr. Venugopal Mahapatra generally accepts.
Yes, it is open to the petitioner to serve copy of the petition on panel counsel, Mr. Venugopal Mahapatra, who usually appears for OP numbers 3 and 4.
Grateful.
Item 20.
May I please, Your Lordship? This is matter of sanction of RACP. Your Lordship, pursuant to Annex. This is Your Lordship's order relating to SCB. Only change to the RACP. Yes, I challenge it. I changed it. Well, my prayer may be quoted, my Lord. Only my prayer may be quoted. I change it, my Lord. RACP.
This sort of. Always give one copy to the other. Otherwise, they will not be able to know which.
No, already. Already. My prayer may be quoted.
Yeah.
Item 21.
May I please, my lords?
Yes.
Here is the case, my lord. The petitioner was granted scale grade pay Annexure 3 and Annexure
Rafiq Mercy.
You know?
Rafiq Mercy, covered by Rafiq Mercy.
And what happened? The kindly say Annexure 4 page 17.
They take notice. Now already recovery is done.
No. I retired just now, no recovery. But what happened?
Annexure 6.
Annexure 6 kindly
for reconsideration.
No, Annexure
of action shielded.
You consider.
Yeah. Never consider till date. But what happened?
What is that? I am agreeable and still you want to argue to pollute the case. This is the petition prayer reads as counsel for the petitioner submit that the client has already made a representation for reconsideration of the decision.
And I am not fighting. OP number 4, data set submitting. OP number 4, Annexure 6. Direct
1925 Annexure 6 is what?
Annexure OP number 4, direct OP number 3 to submit the divide pension papers. OP number 3 sitting over the matter. For reason that I am not getting pension matter.
1920.
That is my entire.
Then again you will reject it.
No, my lord. Sir, this is for reconsideration of and resubmit the proposals.
Correct, but
so they have to resubmit. Then cause of action will arise.
They are not submitted. I am not getting pension, my lord.
Where is cause of action?
I am not getting pension. My cause of pension.
My lord,
that is subject to your complying with the conditions.
No, I am not. That I am only 5 minutes, madam. I was granted scale of pay of 8,700.
Correct.
That was under Annexure 4 modified by the OP number 3.
Yeah.
But while submitting my pension papers by to OP number 4, that are not reflected in service book. For that reason, opinion number 4 directed to resubmit his pension papers, and opinion number 3 sitting over the matter. As a consequence, even a retired since not getting pension benefits. That is my entire defense. Already they have reduced, I accepted it. I have never challenged.
That is by way of recovery.
No. They have reduced on scale of pay. That I accepted.
But why you quoted Rafiq Masi?
Rafiq Masi, because in Annexure 6, they had to recover the amount 97 to 2007.
That's what, therefore, I told you.
Yes, that's why that recovery I have made for Masi. I will tell person, madam.
Where is the order of recovery?
Yes, kindly see.
Where is that order of?
Yes, kindly see, madam.
22 to 2017. 1925.
Yes, 17 I accepted. I accepted the reduction pay. In that case, can last for the excess amount from 2007 will be recovered. The Annexure 4, but not recovered till then. Again, Annexure 6, the same has been related, my lord.
Mr. Behra.
Yes.
His prayer is that.
Para 3, the excess payment in.
All right. You should look at the judge.
Sir,
I am the grade of the judge.
Reading, madam.
How I should impress him?
Sorry, madam.
It's not like that. Anything you will. Yes. Issue emergent notice, where I requested of sub notice for the this. Petitioner has moved an application in IA number so and so verify an affidavit seeking the grant of interim protection.
There is no application.
No application.
No.
They cannot say that.
No recovered till that, madam. They are not recovered.
All right. Issue emergent notice. Behra accepts notice.
Only a pension case. Pension also short dealt with pension case.
I cannot do anything. You know, at least an application should have been moved so that I could have said, what is the urgency?
Take on next time, I'll buy in the meantime.
Next. You have already wasted 10 minutes. Yes,
short dealt, my lord. Short dealt with it, madam. Sorry.
Wasting time of the proceeding, all irrelevant. I think if I go by your opinion, you should be truthful. I assume that lawyers do not mislead me or they do not That we do not mislead, I agree. I have seen you. You never even mislead. But you waste time of the court. Point. You have no art of formulating the point or consideration at the initial point. That is the problem. You are arguing those things. Very simple point. If you say Rafiq Masi, the whole lot of judgments will come in front of my mind. Then you can start. My lord, this is covered by Rafiq Masi.
Like Jogendra Sahu, also I will.
Let us.
Well, maybe the petitioner is working as a section officer. Annexure 2, page 21, he was earlier transferred to a place of district education officer Nuapada by virtue of order dated 7/12/2023, page 21. And thereafter he joined. And government guideline will Annexure 5, page 25 says, my lord, 20th August 25, that as per the GA Department circular dated 1/92, the ministerial officer who have completed 3 years at a particular station should be transferred.
Transfer of ministerial staff.
After completion of 3 years, they will be transferred to other station. The government guideline 92 it was followed, and the recent guideline following that 92 guideline, the director of secondary education, Annexure 5, page 25, on 20th August 25, has directed all the DO, district education officer, to implement the same. And I was only completed 1 year 8 months in the presentation. And Annexure 6, I was transferred on 6th September 25 to another place, deviating the government guideline. I approved this on court, Annexure 7. Your Lordship granted me interim protection and directed to DO to reconsider. Now, my lord, I have approached the authority. Annexure 9, they have rejected only on the same ground that I have completed in the district as 3 years. I was earlier appointed, continuing and block education officer Nuapada prior to 2023. Yeah. Thereafter, December 23, I was transferred to district education officer Nuapada. That is 2 separate stations, 2 separate offices. But now the DO stated, my lord, Annexure 9, page 34, by rejecting my claim that you have completed more than 3 years in a particular district, therefore, this is not rejected my case.
Appears to be sensible. What is the
government? You'll also kindly see government guideline, my lord. Yes. That is, my lord, page Annexure 2, the 11th, first, my lord, the GA Department guideline is, my lord.
2 is not guideline.
No, 2 is not. Well, Annexure 5, relevant page, my lord. This is the 92 GA Department circular governing the field, para 2. In view of this, it has been decided that 50% of the ministerial officer having completed 3 years at a particular station should be transferred
other station.
Correct. My lord, I will also kindly see Annexure 2, page 21. I was working as block education office at the block education office Nuapada.
In the same station.
No. That's kindly told you.
Which is different. Station
is different, my lord. There are two separate district office. Block education office, something different office, and district education office is another office.
No, the question, the guideline, the focal point of the guideline is not the force at the place.
And both the stations function in two different places. Not in the same campus or not same area.
Different
campus, different area. One district.
Are they in the, what is meant by station?
Station, my lord.
Same place.
Same place. Yes. I was continuing, my lord, at the office of the block education office Nuapada. I was transferred to.
You have said it now.
District.
I'm asking, where is the change of station?
Change of station because of the place of posting one place to another station.
Which place you are working? Which place you are posted now?
I was posted at my block education office Nuapada.
BO
Nuapada. To transfer to the post of.
Then from transfer to
district education office Nuapada.
District change of place.
There are two.
Office is different.
Office station
is different.
Yes, and the guidelines says station.
Station is same.
No, station is not same. Why? Because you also kindly let them take instruction.
No. Where is the? You should convince me.
My entire case, both the offices are functioning two different stations.
What is meant by station?
Station that it has not been indicated in the circular.
Common parlance. Common sense.
Yes.
Station means that area, that particular place.
Yes. Here, my lord, both the offices is function in one district. Suppose my Kotak district, there are several offices. I was one employee transferred to another district in same district, but different station. I was posted in a block education office in a different place and different station and transferred to other station. And now also kindly see.
Petition is rejected.
One more round.
The transfer is not from one place to another, but in the same place. Maybe the post may be different. First. Secondly, the guidelines are guidelines, though they may have statutory force. Mere violation of guidelines in all cases invariably will not give a coherent cause of action. First. Number three, what prejudice is caused even if guideline is violated, is not demonstrated, despite the vociferous submissions of the counsel for the petitioner, are rightly submitted by ASC appearing for the next.
One more round.
Thanks. What is that? Nothing except next.
Item 23.
Then after filing the petition, now they have rejected my leave application. You also may dispose of because allow me to.
You withdraw the petition then.
Dismissal maybe.
Petitioner, having argued the matter, seeks leave of the court to withdraw the petition with liberty to
join in the new place of posting.
Join in the new place of posting. Within what period you are?
7 days.
Within 10 days.
10 days.
Within 10 days. First term. If there is any other grievance, liberty is reserved to the petitioner to work out the same in accordance with law elsewhere. In that connection, all conventions are kept open. Yes, next.
Item 23.
Yeah. 23. Issue school leaving certificate. Also, they should come to the court.
Private education.
You accept notice. But they are under your control.
They're not school.
No, education. Whether private or for, they are all covered under 226.
They have to issue certificate.
You are not party. You are 4 and 5. You are appearing.
4 and 5.
2, 1, 2, 3, 1, 2, and 3. First of all, the ASC is requested to accept notice for 5%. Since matter appears to be urgent and short, push the same. Push the same thing. We copy. Give copies and other things.
Okay.
Item 4.
Second round of litigation, my lord.
Yeah.
I'm challenging rejection order Annex 10. Similar matter was already issued notice.
Notice is issued.
Yes, the rejection of revised scale of pay, they have now rejected.
Say, follow. Yes.
Item 25.
25, my lord, already passed and challenge the transfer issued by the MLA, instruction of the MLA and MP. My lord, I will keep a copy.
You have the copy.
My lord, I've already posted to second.
And dispose of the matter.
My lord, I've already fixed to 2nd of November.
You make complication.
My lord, there are 3 grounds, my lord. There are 3 grounds, my lord.
You challenged very.
My lord, even if the MLA account notification, it says the session May to June. Even October they are doing, my lord, relying that notification.
Same, madam. Yes, he is requested to accept notice for the office. All office.
All of my lord.
He has already been relieved by Annexure 7.
No, they have given it, but I'm challenging that. No, my lord.
If not relieved.
If not available, only if petitioner is not relieved from the place.
My lord, directed in that they have to allow continuous same place before you have a passport. But I'm not relieved, my lord. That already passed, if not relieved.
If already not relieved. Because it will create problem to the other students.
Also the other successor, my lord.
The batch case.
Item 26.
May I please, Lordship? Yeah. In this case, Lordship, petition challenge the revised final answers. Similar matter, Lordship directed and order passed, interim order.
What is the interim order?
To keep post vacant, one post vacant. Lordship. The Absolution Commission, the separate panel, my lord. I am for the opposite panel, one.
Is for one.
Notice to.
Two. Well, there is a staff council for.
Yes, my lord. Lordship.
Who is that council? There is a panel council.
Yes, my lord. Yes,
Right, but the panel council is especially to accept the number. First, even then petitioner shall take usual steps in respect of the said OP immediately. Any
Your Lordship.
Same one.
Some item both
WP number.
matters.
Both the matters.
Your Lordship. 3 matters there. Sub item. Comments.
Item 27.
Yes.
Here, my lord, petitioner was appointed as a lecturer, my lord, and as a
Lecturer in computer science.
My lord.
What they have done?
While he was continuing, all of a sudden, my lord, October 25, 8th of October 25, he was not allowed to, and he was prevented to discharge duty. He immediately sent a mail to the authority concerned under Annex 4, page 17 and page 18. Now they are not taking decision, and it was long that they are going to appoint persons. In spite of that, petitioner was appointed proper selection, my lord, and continued since 2022 without any problem. And petitioner was also appointed, my lord, and you see, as a, sometime in the, as a admission in charge also, Annex 3, my lord.
Class suspension means what? Yes. Class suspension.
Class one, they didn't allow to take classes. Now, my lord, they are not allowed also to put the signature in the attendance also, my lord. That amounts to termination in view of the judgment of this honorable court in case of the prevent an employee, it amounts to termination in view of the judgment of the Dhaneshwar Naik, my lord. Paragraph 12.
That's all right. That's you of many people.
My lord.
To take emergent notice.
I'm only that post will be filled up with my lord.
Issue emergent notice. Council for the Shri. All the they appear already.
Only three note.
Emergent notice to 3, 1 and 2 ASC. In order to the effect that the post in question shall not be filled up till next day of today.
I have given a quarter in that campus, my lord. My all utensils they are in the quarter. They are not allowed to enter into to bring back or to utilize, my lord. I have hired
Council for the petitioners. Unless ingress and egress to these official quarters is permitted, Client and his family would be put to a manifest injustice. There appears to be some well-known case for making some provision. Therefore, petitioner shall be permitted to have ingress and egress to the official quarters and also to stay therein till next date. Subject to usual terms. You have to pay rent, etc.
In this case, the petitioner telling the non-grant of remaining part of the area amounting of rupees 4,80,000, it is 380 again. Rest amount already out of 15,50,000 source of oil is 642. Already rest part really in my paper.
This part is not given.
Not.
Annexure 4, you have given the representation.
Yes, ma'am.
If decision is taken on that, it will be helpful to you. Or you want notice to be issued.
That to consider the concept with the stipulated
petition prayer leads at that.
Better prove direct.
Copy number 2. Petitioner draws attention of the court to the representation made by the petitioner at Annexure 4.
4, my lord.
Annexure 4. Very. Here, check. For release of GIA salary amounting to rupees 4,80,380. Counsel for the petitioner submits that. Although other terminal benefits have been claimed, this part has been unjustifiably retained. And therefore, interference of this court is not. Next one. But it is appealing for the votees, although initially opposed the petition, now briefly agrees to instruct OP number 2 to take a call on the subject of presentation within a reasonable time and in accordance with law. First, the mediation puts the KVA that all conditions of the party be kept. But with this counsel for the petitioner is agreed. Next, in the above circumstances, petition is disposed of. 8 weeks, solicit, etc. Registry to send a copy of this order to OP3, you do not appear.
Yes, madam.
You appear.
No, in the registry
to send a copy of this order to OP number 3 for doing the needful action. Information and doing the needful action by speed post.
Second, same one is the same malado. Only amount of 4,93,079 rupees. Out of
93,070 instead of 7,80,000.
Out of 8,80,889 rupees.
That is reflected in the
paragraph 6.
Representation.
Representation also.
Item 29.
May I please
Mobilization score.
Your Lordship, petitioner, they appeared in the junior teachers examination, but their result were never declared and neither the cut-off mark, Your Lordship. And they, Your Lordship, here what happened, batch of candidate was already before this honorable court challenging the selection process. There was a change in the selection process which they have challenged and it is pending before honorable appellate court. Here, in that case, Your Lordship, there was a direction for appointment of these to a petitioner. But till date, neither the cut-off mark has been declared, nor the mark secured by the candidates, nor the appointment has been given to the petitioner, Your Lordship. Your Lordship, let notice go. I have filed an IA. So from some reliable source, I have got
meantime,
another advertisement is shortly going to be published.
If it is published, file a memo.
Your Lordship, there are vacancy. I can show it.
Vacancy, all right. If they put forward one step, then you can move a memo and reserve liberty. Or notice go. let them.
In the meantime,
1020.
read and read appeal was there. Subsequently, district wise, they have published the result. Possibly, my learned friend has not received the same. I don't know. In the meantime, this is subject to scrutiny.
Mr. Monty, short matter, you take notice. Next week, week after next, you tell what is happening.
Absolutely.
Issue notice. Learned DG is requested to accept notice for.
Yes, ma'am.
Even second also, OCP.
Normal 1 and 2.
Notice for one. Second also you take note 1 and 2. Matter lies in a narrow compass and some urgency is pleaded, drawing attention of the court to the interim applications. First, post this matter immediately. Post this matter in the third week of November. It is open to the petitioner to move a memo in the event the fresh notification for recruitment is issued.
Deeply obliged to.
In the meantime. There is a case? Yes.
Very limited question. Only for correction of the critical error. Let's kindly see that the petition is an employee upon an institution.
The correction of date of birth. Date of birth correction.
No, not simple. Birth date is a very, you have seen series judgments of the apex court. Even if birth date is correct, still you will not alter it in the service register because consequences follow. Many of your juniors will not get the promotion at all. Not one example I give. That may not be here. But anyway, you tell it.
And I am not getting my salary irrespective of my discharging my duty. Lordship may direct to pay my current salary.
How? Without notice to them?
No.
So both in read and IA notice we issue.
I have filed an IA.
Both on main matter and application. Post immediately after service. Mr. Monty accept
1 to 3.
1 to 3. Emergent notice to follow. Next. Item 31.
Active on my lords, this is a third round litigations, that rejection order. Anti-rejection of my placement, my lord, that is financial benefits. Anti-rejection of the financial benefit, the government has granted, but I prayed for anti-rejection, lordship twice remanded the matter, and again it is rejected.
Will issue notice, yes, not remand the matter.
No, yours will not.
No, notice be issued. Yes. Because technically, library and technical assistant, these are two separate posts.
Issue emergent notice, OP1 by 1 each year, that will be emergent notice. Hon'Ble University.
Hon'Ble University.
Panel council.
Their panel council. Only one is the.
In addition to taking individual step, petitioner may serve a copy of the petition on the panel council, usually representing the respondent to university, OP number 2 university.
So, for item 30, can also fix a deal with IA is there?
Yes, after notice it will come. I can't fix date in the admission stage. People will say, why is fixing the date? That's an admission stage. Unless very, very special case is made out. Not the practice. Yes. Item 32.
May I please lordship?
Yes,
my lord. Here petitioner is a physically handicapped employee who has been transferred from one place to another place on recommendation of the MLA.
Well, my lord, that MLMP in some of the cases, my lord, is there to prefer the appeal before the appropriate authority.
Yes,
in some cases, notice has been.
My lord,
I protect you.
My lord, let me complete. My lord, I have already filed the appeal, but here I have filed this writ petition only to interim protection, my lord. I am a physically handicapped candidate. I have challenged the circular, my lord. Just 1 minute, my lord. At page 31, my lord.
31?
Yes, my lord.
What does it say?
My lord, clause 6. Competent authorities. An authority.
Teacher can transfer the teachers within 6th of April to 15th June.
My lord.
Now, after that,
my lord,
they have made the transfer.
Yes, my lord. In the month of October, last week of October, and she has been transferred, and at the midnight, she has been deemed to be relieved. But my lord.
But so urgency in the midnight transfer relieving. Any bomb is going to be exploded.
Only, my lord, I pay for interim protection. She may be allowed to continue there and director to decide, my lord. My lord.
Till decision is taken on.
My lord, Annexure 6 is my appeal. Till appeal is decided and she may be allowed to continue there.
Till decision is taken.
My decision is taken. And OP number 4, the BO may be directed to allow her immediately, my lord. This is only my prayer, my lord.
Allow her immediately means?
My lord, she has been deemed to be relieved now.
She should be taken back.
Yes, my lord.
The deeming is, it is used only in statutes.
It is not deeming exactly. The consequences will follow because if at all you will be protected during the preparing the appeal until disposal, that can be concerned.
And the petition prayer is as a concept for the petitioner submits that when an employee makes an appeal against the transfer, the same is entitled to be decided on a war footing in the light of apex petition in Varadhara versus State of Karnataka. First, counsel also highlights the swift action of relieving his client, who allegedly is a handicapped person. First, therefore, he seeks a direction for early disposal of the appeal until disposal takes place for the protection from the effect of transfer order. First, next. Learned AGA, Mr. Mohanty, appearing for the OPs, opposes the petition, contending that there is no immunity to any civil servant from transfer. Semicolon. He or she is bound to serve wherever posted, and therefore petition should be rejected. First, having so contended, now he agrees with the suggestion of this court that petitioner's appeal be heard and decided at the earliest, if all contentions are keeping open all contentions. First, the petition. Next one, in the above circumstances, petition is disposed of, directing consideration of the subject appeal of the petitioner. A copy whereof I will set appeal memo.
Appeal?
Annexure.
My lord, annexure appeal at annexure 6, my lord.
4 series or 6?
Annexure 4 is my transfer order, my lord.
Annexure 6 is there.
Annexure 6. First of all, contentions of the parties are kept open. First, till the appeal is heard and decided, petitioner shall be continued in the very same institution in which she was serving before the issuance of the transfer order. First, OP number 4. OP number 4?
OP number 4 is the relieving authority, BO.
Yeah, he should be directed to take...
My lord.
OP number 4 is to implement the order to continue the petitioner, immediately. Implement the direction for continuance of the petitioner immediately.
Item 36, DPU. Okay.
Yes.
May I please, Your Lordship?
Yeah.
Two matters are there. In one matter, I am appearing that a WPC number 2714 of 2024.
33. Before my learned friend begins, just I recapitulate that two matters before this court and another is before this coordinate bench. In one case, interim order was passed, and another case, by virtue of the interim order, neither she could be returned back to the original post, that is in charge headmaster. For that, my lord has last directed to club up these two matters and had it. Then my learned friend may begin. Exactly.
Both the matters are posted today.
Exactly.
Who should begin first?
First, 2749 of 2024.
27149.
149.
Yes. What is the challenge in that?
Yes, ma'am. Here, ma'am, I have challenged the order of DO, District Education Officer. Annexure 7, page 31.
Dated?
Dated 25/9/2024.
What is that order?
That order says, madam, the DO has directed to allow office part number 5 to continue as headmaster in charge. To continue as headmaster in charge.
He is in your matter OP.
He's OP. OP number 4.
You are also in charge.
I'm the headmaster. What has happened?
No, I'm asking that.
Yes.
That you can explain.
Yes, ma'am.
You are also on in charge basis.
But the appointment order says I am
not answering the question.
I am
hear the matter.
Regular headmaster.
You are regular. That you have to say.
Yes.
You are regular headmaster.
Yes, ma'am.
Why?
Before that, I will draw my lord's notice only one line. Yes. This is a complete privately managed school. No government aid.
Can you prepare?
Yes, that's it. It's a completely privately managed school. The lord's may turn to annexure 1 of my read petition.
Who has posted his client as in charge basis?
I don't. Management is normally the appointing authority. In a private management is the appointing authority. Here my ground is that when he has been terminated from service, the direction to allow him to discharge his duty is not permissible.
He is terminated from service?
Yes. And after his termination, he has also challenged it in appeal before the director.
It is pending?
Yes, it is pending.
Because the order is granted there.
No one. Yes, because there is no service protection, only one in respect of private managed schools, my lord. So there is only one notification of the government. Their government has decided to those who are terminated, they can prefer an appeal before the director. That is the notification of my lords, that 27/3/1983.
Under that appeal is provided.
Under that appeal is provided and admitted fact he has preferred an appeal.
But termination is not a state.
Not state. And I'll bring my lords, then I'll bring my lords the fact, what are the facts and what. Let me turn to annexure 1 my appointment order.
In the meanwhile, can I have some clarification from him?
Yes.
Who appears for the management?
No one, because in the what has happened, my lord, in the meantime, management has not been approved, reapproved, my lord. I can say because the term of the management has in the meantime expired and
it is not extended.
Yes, and proposal has been submitted. It is not approved by the director till date.
Yes, sir. One question. Whether your client was terminated from service?
Yes.
On which date he was terminated? Date of termination?
31/1/2024.
31/2024.
And exact?
Annexure 4 of my read petition, my lord.
Page?
Page, my lord, 19.
He has preferred appeal.
Yes, he has preferred appeal.
Appeal number is?
That in his counter, he has stated that appeal number is not provided.
Not provided, but appeal is filed.
Appeal is filed.
Appeal is filed on that he has stated in his counter. He has preferred appeal on.
On 9/1/2020, he has prepared 2 appeals, my lord.
Why 2 appeals?
I don't know, my lord. He has stated in his counter. The lordship can find it.
Filed on?
One appeal on 9/1/2025 and subsequent appeal petition on 25/8/2025.
Why another appeal? Why
Additional facts drawn to the notice. Some facts.
No, I'm asking you. You are terminated. You have challenged it. There is no interim order of stay of determination. What's your right to be in the in-charge position?
Now, let's my answer to Lordship's query is, Lordship see the conduct first. Let the government file the government records is there. Let I am a senior most person, admittedly, not disputed, and he is junior to me.
Correct.
Headmaster post calls vacant. The management illegally appointed him as headmaster.
Yeah.
In my place.
Yeah.
So accordingly, I approached the authority, that the DO, District Education Officer. The District Education Officer directed the Block Education Officer to conduct an inquiry and submit the report. The BO submitted a report saying that yes, he is the senior most person, he should be appointed in that place. So accordingly, the DO directed the concerned management to appoint me as headmaster. Now at this stage, Lords, by that time there is no termination. Let's visualize. By that time there is no termination. And to forward the order of the higher authorities, now the management, with certain oblique motive, pass an order of termination, which is non-honest in the eye of law. For that sake, by your abundant concern, I filed the appeal. I am accepting, Lord. But you also visualize, so far as the appointment of headmaster, I am a senior person.
That's not it. You have said it. How a person who is terminated, can he say that I am the senior most?
No, I
you
cannot.
Terminated.
No, terminated. But before that, there is a direction. Only for Lordship's convenient, thrice there is a direction. I approached the Lordship directed the DO directed him, and thereafter they passed the order of termination. This is the question. That is the Lordship's decided.
Now, you may have a good case in appeal. That's another thing. Till termination is set aside. How can you hold a very post, whether a charge in charge basis, independent charge? How can you hold that?
No, I cannot.
What is the right of
I cannot. I do accept the Lordship's position. Nobody dispute this. But here the question and the entire fact now is for Lordship's.
What facts? Where is your appeal is pending? I don't entertain all those things. Your appeal is pending. You argue all the facts.
No, that Lordship prerogative. I cannot say that. Lordship prerogative. Why the Lordship say found that the order palpably wrong, without authority or mala fide, more particular to forward the order of the higher authority. Thrice, my lord. You see, thrice prior to.
No, you can have good case on appeal. I agree that you may succeed before the appellate authority. Going by your version, you should.
No,
that cannot be subject.
Only I think notice while you are also exercising the 220 jurisdiction and while there is no disputed facts. And for
where are the disputed facts? You admit that you have been terminated and you have filed the appeal.
That is not disputed. I am accepting.
Therefore,
there is no disputed.
We'll direct the consideration of your appeal at the earliest. Till that happens.
No, you don't say that.
You yield place to him.
No, you don't say that.
Because if I write more, that may pollute your appeal.
No, obviously. I am not disputing. Only I am saying that under Article 226, when there is disputed question of fact, and the fact is the order is government order is very clear. And
where is the disputed question of fact?
No, here.
Which fact?
We am accepting the terms. I am accepting. I am not disputing.
There is no dispute.
No, I am accepting. So there is no disputed question of fact. And if
so, I am proposing this.
Yes.
Instead of writing, I am just putting it to you. I can write it within 1-2 minutes. But that should not affect anybody's career in appeal. Appeal's merit should not be affected. My order should not cast a shadow on your appeal. Therefore, what I suggest is, both the sides having argued the matter. This is suggestion.
Yes.
Because this is what Section 289 of CPC says. I should make all efforts to settle the dispute between you people by conciliation. If you do not agree, I will impose my order. That power I have.
No.
I don't want to exercise that power at all.
Proposition law is concerned.
Therefore, what I suggest is, suppose will you be happy if I write dispose of both the petition, saying that you should prosecute your appeal to be heard and decided within a period of 8 weeks. Okay, all contentions are kept open. Perhaps he is also party there. It appears is the appeal, and till the appeal is heard and decided, and subject to that, the person shall hold the position as before. Simple. So that it will not affect. Yes, no, I cannot say more on your.
No, my lord.
That may affect his case.
No, my lord. That I agree with my lord's thought.
both the sides, whether you are agreeable to it, both the sides, having argued the matter vociferously, now graciously agreed with the suggestion of this court that the petitioner be placed in the office of principal, headmaster,
In charge.
on in charge basis. No, regular. No, we'll put you now in charge basis because his appeal is pending. Suppose if he says
He in charge.
But
he says no. On in charge basis. He may run the risk also. Let it be on in charge basis. Once his appeal is rejected, that becomes regular.
yes, madam, I don't dispute that, your lordship.
Correct. What you want to do? Prophet? Agree with the suggestion of this court. Placed in charge of office of the headmaster into brackets on in charge basis. Number one. Number two, the OP number 3, OP number 4 shall forthwith yield the office to the petitioner, subject to outcome of his appeal pending on the file of
Director
Technical Education. Secondary Education. 2 appeals actually.
This he has stated 2 appeals.
Right. Appeal, into brackets. Yes, also. The subject appeal shall be heard and decided by the Director of Secondary Education within an outer limit of 8 weeks. 8 weeks. On its intrinsic merits. Without being influenced by this order. And that all contentions are kept off. Next one. Ordered accordingly and writ petitions are.
My one prayer, in that DO order to allow him to continue that observation, your lordship.
It hardly needs to be stated that the order of the impugned order of the DO dated
my lord, 25/9/2024.
25/9/2024 at Annexure 7.
My lord.
Stands invalidated.
No, you have to say to pass any order. So that order is to be invalidated because director is to pass an independent order.
Instead, what I will say
is first,
what should happen to the in charge arrangement? He is subject to
that first line is
because this may not be.
Yes.
Again, he will come before the court saying that it is without jurisdiction.
Yes, ma'am. Yes, ma'am.
That last line. That last line you delete. What should happen to the in charge arrangement to be brought about by the order of this court now shall depend upon the outcome of the appeals pending.
Yes.
Within a few minutes, I'm back. Back to them.
The petitioner transferred from Keonjhar to Jajpur Road, my lord, which is about 150 kilometers. My lord, petitioner husband is servicing the same station in different school, my lord. Thereafter, what happened in file representation that 2 children are staying with her. One is about 1 year and one is 2.5 years. So that's why file representation at Annexure 7, my lord. Spouse case, my lord. Both are
ground.
Yes, ma'am. Both are staying at the same station in different school.
Yes, Mr. Monty, what is saying?
They have not served the copy. Entitled on the spousal ground and filed the representation.
My lord, copies.
No, without serving the copy.
Possibly office has not supplied that.
Your officer has not sent.
Yes, Adarsa Vidya, possibly on wrong notion.
The state is also party. OP1 is state.
OP7 is that Annexure 7 is
It's a normal.
your representation.
Yes, my lord.
You have made it to state project director.
OP number 2, my lord.
He has to take the decision.
Yes, my lord. That is on coming under the government, my lord.
Somebody else said 4 kids are there. Other 2 kids you have got from whom?
Two kids. My applicant has 2 kids only has about 1 year and another only 2.5 years, my lord. That is at Annexure. Annexure 4, my Annexure 6, my lord. On date of birth is
Krishna. He is knocking at the door. Kindly be seated. Knocking at the doors of High Court for assailing the transfer order dated 2025 made by
petitioner.
Number 5.
Are it transferred, my lord?
No, OP1.
OP1, 4, my lord. That is OP number 2, my lord.
OP number 2.
Yes, my.
By OP number 2. At Annexure 4. First, counsel for the petitioner submits. Can you be seated? Yes. Counsel for the petitioner submits that the apex court in Varadarao versus state has held that it is open to the employees to make representation against the transfer orders. And if such representation is made, a decision thereon has to be taken on a workwood. He also draws attention of the court to the spousal ground taken and also the hardship which the family of the petitioner would be put to because of transfer. When there are 2 kids, first, he further submits that whatever be the merits of his of the subject representation, decision has to be taken, and till decision is taken, the petitioner should be protected from the agony of transfer. First, next paragraph. Not an easy feeling for the OPs, official OPs, opposes the petition containing that there is no immunity from transfer in public service. But he also quotes further out in support of his contribution. First, next one. Having heard that the counsel for the party, that they will peruse the opposition paper, this court is trying to grant indulgence in the matter as under inasmuch as it agrees with the contentions taken up in the petition, coupled with the submission made by the petitioner's counsel, which accords with the broad view of the apex court as has been expressed in Varadarao and such other cases. First, next time, in the other circumstances, petition is allowed by a writ of mandamus issues to OP number 2 to consider petitioner's subject representation at the earliest, and till consideration takes place, petitioner shall be continued in the same place as she was before the issuance of she was, before the issuance of inducement for us. First, all contentions of the party are kept. It is open to solicitors, no cost.
Published.
Item 35.
I think my lord.
Yes.
Sir, my lord, the FO which has been filed before this Hon'Ble Court, that has been dismissed only on the ground of limitation, wherein it should have been filed within 60 days, but there was a limitation of 978, my lord, 2 years, 8 months.
Whether there is provision for condonation of delay?
Yes, my lord.
There is?
Yes. But only on the ground of limitation touching the merit that has been dismissed. For that, this review has been filed for recall.
Lordship, you said the issue that review is not maintainable per se.
Yeah, that was your submission, length of submission, and I accepted it.
Yes, Your Lordship. It was judgment, Your Lordship, for it.
Why my judgment is there?
Yes, Your Lordship, I got that.
That was your submission.
But if it may be recall, I cannot say the nomenclature as review, but only on the ground of limitation. My lords know the
review only. Recall and review. Suppose if you touch the merits of the case, which includes limitation,
yes,
it's a review. Other than that, because you have not been heard in the matter, that is recall. Because you have no power to pass the order at all.
Yes.
That also can be recalled.
Without extending the opportunity. But here only on the ground of limitation. Mela. It is an admitted fact that there is a limitation of 978 days.
But how this is maintainable? Because of the law declared by myself. You ask me, in one matter you hold the review is not maintainable, in another matter you hold that review is maintainable, which to follow? And unfortunately, you call me for many programs. People ask me what I should answer.
No, we cannot canvass in both the way.
That's what.
Retraction and protraction.
Approbation, reprobation. Okay. This review petition seeks the recall of the order dated
9/5/2018.
9/5/2018.
9/5/2018. Whereby, what is that? FAO number?
It is FAO number 696 of
2015 was disposed of. First, learned counsel for the review petitioner, namely EGA Mr. Mohanty, submits that there is a delay of
978 days.
978 days in preferring the GIA case.
First appeal. Under 24C of the Orissa Education Act.
In preferring the first appeal. Under section 24C of the Orissa Education Act 1969, which aspect has not been duly adverted to by the tribunal. And therefore, the order in question is liable to be reviewed and recalled. First. Next. Learned counsel appearing for the private OP.
Of all the opposite parties.
OPs. Opposes the review petition by placing reliance on, opposes the review petition on the ground of maintainability by pressing into service. This court's judgment dated 31/7/2012. No. Dated
25/8/2025.
25/8/2025. 25/8/2025. In review petitions RVWPET number 234 of 2012 between Sri Sudhyana Chaudhary versus state and others, etc. etc. First one. Next one. Having heard the counsel for the parties and having perused the petition papers, this court agrees with the submission of learned counsel appearing for the opponents in the review petition that the said petition is not maintainable. Which paragraph, brother?
Paragraph 4.1, Your Lordship.
This court, in the cognate judgment at 4.1.
Yes, Your Lordship.
F. E or F?
4.1E, Your Lordship. Also distinguished the parameter provision of the DRT Act. But even 4.1 is relevant. 4.1A.
4.1A. A and E.
Yes, Your Lordship.
4.1 A and E has observed as elder. Reproduced. Next one. In the above circumstances, leave petition is liable to be and accordingly dismissed. Courts having been made easy. Okay.
Much obliged.
So just okay.
Item 36.
Yes, sir.
May I please so much? Again, it's a matter relating to dismissal of the FAO on the ground that non-compliance of the court's order, Your Lordship directed. If the order is not complied with, then some defects are there by filing the FAO. Your Lordship directed to remove those defects.
Was it a peremptory order?
It was a peremptory order. Due to non-compliance of this said order, the FAO was dismissed. My Lord.
What is CMAPL full form?
CMAPL.
Civil miscellaneous.
Miscellaneous application for restoration in case of dismissal. No, CMAPL.
Civil miscellaneous application. Civil miscellaneous application. PL में कौन है?
Petition. Miscellaneous application.
Notice need not go to the other side because no notice was issued earlier.
No. There is a delay in filing this CMAPL about 622 days.
Oh, then I will not. What is the explanation for the delay?
Explanation was not after dismissal of this honorable court, my lord. We had been to approach the department, law department. Law department opined that it should go to Supreme Court. Supreme Court, they refused to file SLP. Again, it came back, so it took some time.
No notice is issued to the other side.
No.
Let us see. Let notice.
Yes, madam.
Issue a merchant notice.
522 days delay.
Therefore, let notice go. Suppose if they agree for taking money and condoning delay,
notice
then let notice emergent. Returnable within 6 weeks. Yes.
Item 37.
File this IA to dispose of the writ application in the light of the another judgment which clearly directly covers the point. But the short facts is there. The petitioner was appointed as a teacher educator. The organization that was the post basic school. The purpose of the school was to teach give training to the primary school teachers. So the designation teacher educator, then this promoted a senior teacher educator, then government created a organization called for this purpose, Diet for the Institute of Training, District Education and Institute of Training. For that, so that principal was created. The petitioner was posted as principal, and the other person who has already succeeded the writ application, which has been confirmed by the Supreme Court, he has also appointed the principal. Principal same order. But what has happened? Why he had filed the writ application? Because he was teacher educator. They were posted as principal, but from another school wing, some other persons are also posted as principals. But their scale of pay was much higher. Our scale of pay is 8,000. Their scale of pay is 9,000. So that is the
reason why the other petitioner in the other writ application, he filed writ application that there cannot disparity on the same scale because we stand on the same footing. So this Hon'Ble Court, after a detailed judgment, delivered and decided that no, there cannot be discrimination. He is also entitled to the same scale. Accordingly, that judgment was. I have also filed copy of that judgment as annexure 7 at page 35. And the judgment was challenged before the writ appeal. Writ appeal was dismissed. Then the government again went to Supreme Court. Supreme Court also dismissed. So those orders I have filed. Your Lordship will check that page 44, my lord.
Can there be two sets of pay scales for the same set of work?
My lord, in fact, we have not filed counter in this.
But counter, my lord, because it's just
only I had received the draft counter. Draft counter is with me, my lord. If your lordship will give me some time, we can file the counter so that it will be easier. So
similarly to lordship, may kindly see
on the 18 we'll call this matter.
On
18th,
my lord.
Knowledge?
Yes.
Call this matter on 18/11. Stop. In the meanwhile, counter, if any, may be filed by the other side.
Also, please.
It appears to be covered by the judgment.
My lord.
But then another way, how can there be two sets of people?
No.
Two sets of people.
My lordship, what I had seen the instruction, it is that person who was for a particular some time only, limited period, he was working as a principal of diet. And this man, sorry.
Not me, means your client.
He missed that. No, he missed that. That automatically said.
My lord, this man was from, he got promoted from the hierarchy, promotional hierarchy it is there. But the other man against whom he is claiming the parity, he is not from that.
Yes, exactly.
No,
how can there be two escapes?
No, my lord.
Merely because mode of appointment to the post is different.
He is from Poyas cadre.
That was the argument. That argument was rejected by the Hon'Ble Court. That argument rejected by the Hon'Ble Court. And ultimately, up to Supreme Court, the last
filing of the counter, your lordship.
Yes.
Item 38.
Not one request, not lordships. Along with this case, not another WPC number 23759 of 2024 may be taken.
There is another matter.
Exactly same matter.
Call this matter along with WP number.
WPC number 23759.
Division based matter, my lord.
It's a division bench matter.
No. It's a single.
Sorry.
23759. 23759 of 24.
9.
The last week of November.
Item 39.
38.
38.
I have got the petition. I have filed an amendment petition. That petition has been notice has been issued. Interim order was there. I have served copy of the amendment petition.
What is the amendment? What are the facts of the
formal amendment? Some mistakes in the address, some mistakes.
This is division based matter, Wakaf matter, division based matter.
Wakaf matter, this court cannot treat it also. Allocation is to the division bench. Registry to examine as to whether the matter should go before the roster bench, into brackets, the division bench. And take a decision on that. Okay. As submitted at the bar. Okay.
A copy of amendment petition have already been served.
But anyway, I cannot treat, if I don't have roster, I cannot treat any application. I cannot dismiss also. Yeah.
Item 39.
Yes.
In this case, I have filed a IA number 18673 of 2025 for appealing for a stay of operation of the public notice issued by the headmistress of the school, and the date has been fixed to today.
Public notice for?
For the constitution of the alumni committee of this school. So, but in the cause list, my lord, it has been reflected IA number 763 of 2025. Whether it is wrongly typed or I don't know.
That number to be rectified.
No, my number is I filed 18673.
No, your IA is for what now?
And the IA, the listed listing is saying that 18763 of 2025. That is not my IA.
Yours is?
I have filed 18673.
18773. But correction, it has come now.
No, it is wrongly typed most probably.
It is typographed wrongly.
Most probably because
In the order.
no, in the cause list.
Cause list, sir.
IA number is wrongly typed.
Learned counsel for the petitioner submits that IA number is wrongly mentioned. First of registry to look into the same. All right.
And IA number, so 18673 is concerned.
Let it come. Let them rectify it first.
I pray after today is the meeting, they have been fixed today.
I will not halt it, otherwise also. That will be subject to outcome of the petition.
No, that has to be stayed.
Why?
Yes, because in view of the resolution, decision taken under resolution by the state government, there is the government has not taken any decision to reconstitute the alumni association, which has been constituted in the year 2018.
Who is the opposite party?
Opposite state.
State?
Yes, only it has been renamed. But they have taken step to reconstitute. That is the problem. Kindly have a glance. I am filing to the affidavit. That resolution copy also I am filing. Kindly have a glance for a moment. That has been renamed. And the existing committee will serve to continue. That is the decision of the state government. But DU has taken state decision to reconstitute the entire body. That notification I filed dated 2012-2024.
Mr. G, what he says appears to be sensible. Change of name is
only rename. Change to rename. The government has taken decision to rename that project scheme.
Application IA number 18673 of 2025 is moved, supported by an affidavit seeking interdiction of reconstitution of the committee in question. First, counsel for the petitioner submits that today a decision is being taken for reconstituting the committee when the present committee is still in operation, although with the change of its name, and therefore it should be, the process should be halted. First, there is a herring of force in this submission. First, no objections are filed to this application. Added. First, a change of name cannot be construed as affecting the very constitution of the committee itself, as rightly argued by learned counsel appearing for the petitioner. Names occur and change, but the body continues. First, next, in view of the above, the application having been favored, comma. The notice dated
14/10/2025.
14/10/2025 issued by OP number 5 at Annexure 10 is hereby stayed.
If possible, urgent copy in course of the.
Yes, it will be posted today.
Item 40.
There is a typographical error. As noted, noting has come. It was typed out at 28997 of 2025 instead of 28289 of 2025.
The order number 1 dated 17/10/2025 comma, mentions IA number 28997 of 2025, when it ought to have been 18289 of 2020. Is it right, Mr.?
Yes.
First, registry to is effect rectification. Up. There is.
Item 41.
Yes, sir.
This is a matter. The petitioner is a computer organization who has been allotted with the imparting education in the.
You have to bring a taller mic to match his tallness.
Due to throat infection, I am not in a position.
Not well.
Okay. But this is a matter.
We'll have it some other day.
No, it can be disposed of.
Disposed of. Yeah.
Your Lordship, the computer organization has been allowed to impart education in different colleges of the 3 districts of the state, my lord. And till 2019, the petitioner is continuing in different colleges and imparting computer education to different students also. It is a self-finance scheme.
2019.
19, my lord. Suddenly in 19, they have told that it will not be continued. If the college will continue them, then their own risk. And your lordship has protected the petitioner and directed to be continued. My prayer is that, my lord, now it has already been so many years have passed, and I am continuing in this said colleges, my lord. So if the petitioner will approach the authority again, they will consider it. Till then, I may be protected, my lord, because till today I have been protected.
You have interim order till date?
Yes, my lord.
On what they have to take the decision?
My continuation or my payments are there also.
Annexure 12.
Yes, my lord. Annexure 12, they have.
Commissioner cum secretary has
yes.
order.
Yes, my lord. Reconsider my case. Because by virtue of the interim order, I am continuing till that. Your lordship is directed to allow me to continue.
Mr. G, what is your contention in the SO, in the counter?
My lord. Your lordship, in the contempt, my lord, there is a contempt.
In paragraph 9, paragraph 10 of the counter, they have stated.
Coming to that. In the contempt, my lord, a suppose was filed. Paragraph 7. In the contempt. Suppose, after receipt of letter dated 31/10/19 from the principal FM Autonomous College, Baleshwar, seeking for clarification regarding continuance of joint venture computer courses through the firm Computer Point, it was clarified by the opposite party number 1 by letter number so-and-so dated 13/11/2009.
Because the computer courses are computer courses are not renewed.
Permission to the firm to run the course was until the academic session 2015-16.
Right.
And thereafter, no renewal was granted to the firm for the said purpose after March 2016. In view of renewal of the joint venture computer courses run by the firm after March 2016, the same was deemed to be discontinued after March 2016. It was also clarified in the said letter that in case any college allowed the said course to continue after March 2016, the principal of the concerned was to be held responsible for continuance of such such course in the college unauthorizedly. This letter was challenged before your lordship. Again, my lord, your lordship may kindly have a look to the
So all colleges started offering similar courses.
Similar courses, they have their own courses. They have adopted their own courses.
What is your right of, where is your right of renewal?
My dear lordship may see the interim order dated 26.
No, interim order all right.
In contempt, my learned friend is saying in the contempt petition what objection they have filed, it has not been served on me. It is not with me also. Your lordship, that interim order dated 26/11/2019. I am making a simple prayer in view of the protection given by your lordship. Your lordship has as an interim measure, it is directed that there shall be no discontinuation of the petitioner pursuant to the order by Administrator 12, provided he is still continuing till the next date, my lord. And thereafter it has been extended time.
We have filed vacation of stay in the.
But it is pending. While it is pending, they cannot take a contradictory matter.
You cannot make out a ground from the interim order of the court.
No, my lord. By virtue of my prayer is simple, my lord. By virtue of the interim order, I am continuing till that also. I am imparting education in these colleges. My lord, for that reason, I am saying that now it has already been 6 to 7 years has passed. For that reason, they may consider it. If they will reject it, then I have no case, my lord.
Consider your case for continuation.
For continuation, and if they will reject it, they will go for the first tender. I may be permitted to.
There is no question of tender.
No, it has been stated, my lord. Your lordship see paragraph 9.
Colleges have
no, it is not
courses, computer courses.
Your lordship paragraph 10, your lordship may counter affidavit can see. Paragraph 10 of the counter affidavit, the main case.
No, I'm not on that. I'm asking, where is your right to seek renewal?
No, my lord, I have no right. I do admit. For that reason, I am saying that they may consider it. If they will not consider, because I am till that I am continuing. They have not paid. They have not paid me the amount also for last 2 years.
Whatever services you have taken for that, you have to make the payment at least. He may not be entitled to renewal. But by virtue of the court order, he has been continued. You can't take services without payment because it is contrary to Article 23 of the Constitution.
But here, they have said that after 2016, no renewal beyond the session of 2015 and 16.
Correct. But there is interim order by the court. By virtue of that, they have been serving. Some adjustment of equity has to happen. Nah? Yeah. Otherwise, that amounts to saying you serve, but you don't claim anything. Rightly or wrongly, there is an interim order. Yeah. And he has been serving. Whatever amount is payable to him, on that you have a conference with your client and come back.
They have stated that we will go for competitive selection process in counter affidavit.
That you cannot tell me.
I cannot.
At least whatever services now you have done,
they may, my submission is they may consider my application for renewal or payment of the amount.
Let me consult with them so that.
Yes. Suppose if I dispose of the petition to permitting you to apply for renewal, and also for payment of amount pursuant to the services rendered in view of the interim order, will you be satisfied?
Yes, madam. Till then, I will be protected, madam.
How you? Because where is your right?
Well, interim order is there.
Interim order cannot be.
That interim
order itself they have sought for vacation.
That interim order will continue till disposal of the representation, not more than it. They may consider it within a week. I am not standing on the way because I have gone through the file. It is a transfer brief after death of Mahapatra. It has been come to me. I have gone through the brief and honestly, I am submitting what is on record, my lord. And since he is continuing since last 16 years, my lord.
Not 16.
Yes, my lord.
Interim order is
no, my lord. Initial appointment is
no, that is up to 15-16.
3, my lord. In 2003.
That's all right. But till 15-16 you did it.
Yes.
Till 19 also.
No, till 15-16 the agreement was.
No, my lord. In 18 your lordship that they are asking for the appraisal report. 18 they are asking for the appraisal report, my lord. 17 they have asked for the Annexure 10 appraisal report. And 18.
Petitioner prayer is texted as under. Petition prayer is texted as under. Counsel for the petitioner submits that by virtue of the pending order dated
26/11/2019,
26/11/2019, the services of the petitioners have been continued with the jurisdictional OPs till date, and that the petition may be disposed of with a direction to consider petitioner's representation for renewal of the license agreement, license for agreement, and also for payment of charges for the services rendered from 26/11/2019 till date. First of all, he also adds that his client would be making an application within 2 weeks, and till consideration of the said application happens, the benefit of interim order should continue. First, next paragraph. The state, having entered appearance through the learned AGA, has filed the counter resisting the petition on merits. First, learned AGA submits that unless a right to continue is demonstrated, interference of the writ court is unwarranted. First, he also opposes the claim for payment for the services rendered on the basis of interim order, contending that any interim order is subject to outcome of the main matter. First, next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court finds that the oral prayer made by learned counsel for the petitioner is innocuous, and that no prejudice should be caused to the other side if a fair and reasonable decision is taken on the representation to be made by the petitioner for working out his grievance. First term. As already pointed out, there has been the interim order since 26/11/2019. That is nearly 6 years. 6 years. And therefore, for a short period, the same is continued. Certainly the heavens are not going to fall down. First, non-continuation may prejudice the arguable interest of the petitioner. First, next one, in the above circumstances, petition is disposed of with the following directions. 1. Petitioner to make an appropriate representation supported by evidentiary material for working out the grievance, both in respect of renewal of the contract or license and also for the payment of the amount payable on account of interim order of this court made on 26/11/2019, whereunder petitioner claims to have been serving, notwithstanding grant of denial of renewal. Number 2.
Before the opposite,
if such a representation is made, a decision shall be taken by OP number
1.
OP number 1. After giving an opportunity of hearing to the petitioner in the matter, regard being had to the complexity involved, within a period of 8 weeks. 8 weeks. First. Next paragraph. Till a decision is taken on the contemplated representation, the benefit of interim order dated 26/11/2019 shall continue. If petitioner makes the representation within 2 weeks, reckoned from this date. First off, last point. All contentions of the parties are kept open.
Contempt application is concerned, that may be dropped. So
yeah, everything will go now. Since petition itself is disposed of, The contempt application pales into insignificance. Okay. Contact 2856 of 2019 pales into insignificance. Yes.
Item 42.
Yes, Mr. Sarin.
Yes, Your Lordship. This is regarding my lord ancient monuments. Protection of ancient monuments. The honorable single bench order has not been implemented. That is why, Your Lordship, that was challenged in a division bench also, which was dismissed at the instance of the persons who are interfering with our licensed photographers. We are the licensed photographers, my lord, licensed by archaeological department. On passing, going through an examination, depositing certain amounts, we have been licensed. Year to year, it is being renewed.
It's an enforcement of the interim order.
No, final order.
Final order.
Final order.
Where is the final order, sir?
Final order is, my lord, Annexure 1. Is 6, 7. Seven to 10, Your Lordship. While placing reliance on clause 8D.
Whether that act is a state act?
Central act.
Central act.
This relating Konark, my lord, Konark Temple, Your Lordship. So, my lord, in fact, there are.
The Harper's license.
Photographers.
Where is the order?
Well, this is the order Your Lordship is looking at. 7 to 10.
7-2. 5122.
5122. Right, Your Lordship. Interim order.
It's an interim order.
Disposed of, my lord.
Petition is disposed of.
Petition disposed. Now, this is the order. This was challenged by these other persons who were really interfering without like. So division bench negative that. State that this one is okay. Now, question is. The co-order to challenge. This order has not been challenged. The other matter which was filed by those
who appears for the OPs.
Lord, we are appearing. My land sister is then court. Is the case? Or is the case? Counter case, writ appeals, writ petition, all are pending. Some cases are still pending before this honorable coordinated benches for hearing. So let them have a copy. Will take instruction in this regard.
As for noting, it is done, but
okay, you copy. Yeah, you have complied with the order. Is it your case that you have complied or you need not comply?
Yes.
There is no compliance, Your Lordship.
I have not even seen the compliance. After going through the noting.
Compliance affidavit filed by
OP3.
Archaeologist OP. What does he say in substance?
Lord, kindly see the last order of this honorable court. Last order.
This is 27/4/2022 of Your Lordship's brief. In this content, my lord. Then thereafter, 2022.
Salary
Salary
second
last order.
Last order is 22/6/22. Hey, you serve copy, sister. You give a copy to your elder brother. Let him look into.
She doesn't have a copy.
You also do not have. So our copy only will give you.
let it come one.
Yes, no, we'll give Xerox that you can. From our machine.
Have a copy land, I may serve the copy to my land sister. Then we take instruction.
No, Your Lordship, there is another angle to it. There are two other writ petitions pending in this.
Still pending.
Three, that is again Your Lordship's assignment.
For me only.
The same act, Your Lordship.
Are they posted today?
No. So what we are praying is, since he is otherwise also not ready, and we also
can post them also
together, along with the writ appeal order, my writ appeal brief for reference.
That last sentence, along with, I did not understand.
Along with writ appeal 81 of 2022, for your lordship's reference, and
This matter.
You want copy of that order?
no. Your lordship may call it along with that because it is disposed of better.
Records to be called.
Yes, your lordship.
Write down those WPs.
Yes.
Call this
3633. Should I give in writing?
Yes. And call this matter along with the following WPs, along with WP numbers. So and so. Registry to keep the record of writ appeal number
81 of 2022.
81 of 2020.
Disposed of.
Since disposed of.
So now that it also doesn't have record,
correct.
Should I take your lordship permit me to take copies by pen drive of this brief, my lord?
Which,
pen drive copy I will take.
Registry to furnish pen drive copy freely to the counsel appearing for the parties if applied for immediately.
You ask you?
Pen drive copies.
No, your lordship is nothing saying.
I am asking our registry to give it to you.
No, my lord. Madam lordship is calling it on which day?
Whichever day you want, tell me which date you want. Because they are old matters, na? In on 26 or 27? Or whichever date you want. Not too early because
if possible,
there is 2-3 days no working, na?
If possible, week prior to that. Your lordship is looking at November.
20th November.
Fair enough, your lordship.
All right. Yes. You have to come out as to why order has not been complied with. Till order is passed, you are entitled to argue everything. Once order is passed, I am very, very hurt in getting them implemented. Rightly or wrongly. Because you have lost appeal also. Yes.
RSCP benefits. Upgradations, financial upgradation on completion of 20 years and 30 years of service.
That they are not given to you.
They are not given and they have no reply is filed.
RSCP.
RSCP. Not so call this matter sometimes in the year 28.
At the request of the AG.
But let them file the ballot.
We shall file it.
In the main way, from there, if any may be. Failing which right to file one stands for petition, and petition would be taken, it may be taken up with face value. Taken with face value.
Item 44.
Yes, my lord.
I have great admiration for his fairness. Not even one word he will not say this side, that side. So many requests I have seen.
Very few counsels do that. Very few government counsels do that.
No, many of you are like that. Many of you are like that. I have seen. But he is very outstanding. He does not waste my time. He does not add one single word, nor he will delete one word. Whatever he stated, he confines it.
He reads the mind of the honorable
Even
judge.
matters are dismissed. He
reads mind of the honorable judge. And that is good job.
He reads mind of the judge with his clean mind. Yes. Yes, sir.
On behalf of my senior Mr. S.K. Rai from the opposite party.
Your what time?
Yes, sir.
You make clear to your senior.
He had rang me up in the morning and
in the first week of December.
No, it's not second week, mine.
And you should seek adjournment. What period adjournment should be is left to the discretion of the court.
It's ordered, my lord.
Very difficult, na? When matters come, we will not take up. First week.
My lord, take the date, my lord.
First week it will come. There is something.
I pray with your lordship.
No, I cannot because I don't know. If the bench is changed, I cannot fix a date for the other court. That's the reason.
if it is possible, my lord, then the first week, second week, because second week of December. Much obliged. Interim order to continue.
Interim order to continue.
All the cases.
In all these cases,
That's case.
what are these cases actually?
My lord, there are 7 cases. 2 cases are the one. 2 cases, my lord, we have challenged the order passed with MSMED, where the one bench had and order has been passed by another bench. This is one aspect. Then 3/4 another.
Things happen here also.
Here also. My lord, and the documents are there. That is also. And another point is that this works quantity not coming within the scope of MSMED. That also had been raised. That objection has been raised. About 3-4 points you have raised, my lord. These are the. And you'll also.
So, on 25th of November?
Yes, ma'am.
27th. He wants November.
28th, can you do on 28th?
28th? How many matters are put in on 28th? 3 matters. We had this also.
So, much obliged. Much obliged. Into what to continue?
Anything more? All right. Welcome back. Which one? Why, brother, why 2 weeks?
More preparation. Last time also I had taken time, my lordship.
Yeah.
Kindly accommodate this time, my lordship.
I am appearing in the 45 minutes.
Yes,
I am in 45, I am for the opinion 5.
Your friend for preparation.
They have already been appointed, your lordship. They are continuing.
Continuing. Honestly, lingering, the point is whether the difference resolution.
Let us see.
That is 2 years after. 2 years after. Because I have to undergo my cataract operation tomorrow.
No problem, sir. I am giving you more time.
20th
of November.
November time was given.
Okay.
Come back.
How, sir? Okay. Oblige me, Lord.
Get well early.
And 46
little pain.
46 counter has not been filed. 46 counter has not been filed.
46,
my lord.
We'll file, my lord, of the draft counter has already been issued, and in other cases we have filed, we will file the first counter, first item, I will file.
Call after 3 weeks at the request of Lord in the ASC, who seeks to file the counter. Okay. Oblige, Lord. Will come after? After.
Yes. In this case, petitioner while working as under the administrative control of the opposite party number 3 since 11/6/1995, and while he is continuing as such, he has approached this Hon'Ble Court under Annexure 5 for his regularization. And
Working from 21/6/96, sir.
Sir, Annexure 5, the petitioner earlier approached this Hon'Ble Court for regularization.
That was, they said what they said.
They said, my lord, ordering part of page 17, in the view of the matter, since the petitioner continues his post and has completed more than 20 years of service, and even though his appointed is irregular, he should be regularly in service in view of the judgment. And the opposite party number 2 and 3 are directed to regularize the service of the petitioner within a period of 3 months from the date of passing of this order.
Regularize the service.
Sir, regularize the service, my lord.
Read it again. In view of the matter, since the petitioner continues 20 years of service, even though the appointed regularize signs. Now what they have done?
Sir, challenging that order, they approached the division bench appeal. Writ of appeal was also dismissed under Annexure 6, page 18.
1 second. This WP order is WP 231 of
No, sir. One double PCL 15725 of 2012.
15725
of 2012. Disposed upon 9/2/2016.
Exact.
Sir, Annexure 5.
Sir, 5.
Sir, page 15, sir. Opposite bid number 2 and 3 approach number 231 of 2016.
Dismissed on?
Dismissed on 6/12/2021. And subsequently they approached the apex court.
SLP?
My lord.
SLP number?
Supreme Court sir number was 4893 of 2022.
Civil appeal or SLP?
SLP sir.
4893
of 2022.
Dismissed on?
Dismissed on 17/5/2022. But after that, my lord, without regularizing the service of the petitioner under Annexure 8, they on 28/2022, they give fresh appointment.
To the same post?
Same post, but as a fresh appointment has been given without regularizing the service of the petitioner. And the post has been created for this opposite part number 3, my lord, Perus, Annexure 4, page 13.
Post is created for?
For opposite part number 3 organization on 21st June 1996. All this post has been created.
Item number?
Sir, 21 to 26. Page 14.
Page?
Page 14, sir.
14.
41.
That post is created for me.
So for this organization opposite part number 3, whom under the petitioner is working.
Awesome. That regularization order was made, no?
No, not that is
different.
My prayer is that without regularizing the service of the petitioner,
after fresh appointment,
they will give fresh appointment.
What do you say, brother?
We have filed the contesting opposite party, opposite party 3 valid.
3.
Yes, I filed my counter affidavit.
Yeah.
We have regularized the service.
You have regularized the services with effect from which day?
So that is the notion. Now he says he should be regularized from the date of his appointment.
What's the law point? When you should have regularized it?
No, we regularized from the in persons of lordship's order.
When effect from which day?
Regulation order tapan
Sir, Annexure 8.
Annexure 8 it has been regularized not.
Where is that?
Page 23.
23,
madam.
23.
Of the writ petition.
This is order
2022.
All right. Order was made on 9/2/2016.
Right, Milord.
You should have done it within 1 month.
So we approached appeal, Milord.
Where is the all appeal you have lost? SLP also you have lost.
Yes.
Therefore, the order was affirmed.
Yes, Milord.
Was there any stay to this order?
Initially, Milord, in fact, I think read appeal, there was an order because your lordship sees the contempt. He had filed on contempt, Milord. The Honorable Single Judge, Milord. Honorable Single Judge said that there is no violation of the order because.
Well, contempt is another thing.
And now he has filed a contempt appeal, Milord.
Correctly.
That is pending.
That need not be pending. We'll do it now.
Pending, and he has withdrawn that. Now the only question is from the date from which he has to be regularized.
At least within 1 month from 9/2/2016, you have regularized.
If you also look at
you went in writ appeal.
Yes, Milord.
You went to the apex court.
Yes, Milord.
You were beaten in the writ appeal.
Yes.
And you were beaten by the apex court also.
Milord.
So your stand was completely rejected by the first single judge, then the division bench, then the highest court of the country, and you don't want to regularize him with effect from the date the order was made by the single judge.
Your lordship, Honorable Single Judge directed to regularize following the judgments. He has not fixed that from which date, Milord.
Therefore, you will regularize it after 1 century.
Not, Milord. After availing all this, Milord, everybody is available to me.
Supreme Court said, where an order is made specifying the period, within that specified period you should comply. Where no order or time is specified, within the reasonable period, it should be complied with.
Right, no.
And that reasonable period is 1 month. This is the 3 judgments.
No, so one thing may pray before us, that two read petitions. Let's give him some time.
No time. What is there?
No. Time for what, Milors? I'm saying that.
No.
Not time for anything, Milors.
For rectifying your decision.
Exactly, Milors. I want to, Milors, convince them, you should comply with the If they don't fail, your Lordship will do this, but I will try to convince them from the date.
No, don't convince them. Try to convince me.
No, Milors. Convince them.
You need not convince he is your client.
Yes, Lord. My duty is also to advise my client properly to antedate the regulation date.
If you give an undertaking, I will not, otherwise I am imposing cost of rupees 25,000. Why are you making them to court? How many times he should come to the court? He will spend whole of the worth of his life.
That's why I'm not taking for longer time.
No time will be granted, sir. I will not grant time. I can't waste time. I will not waste time. If you have any point to argue, you tell me. You have lost the case at the level of...
I don't dispute that also.
You don't want to regularize his services.
That is why, Lord, sir.
Where is the fresh appointment order?
That is Lord, sir.
Page 23, item 8.
Is it fresh appointment?
Yes.
Have they said that?
Sir,
cost is 50,000. You are playing with the lives of the common people. We can't allow that. You have no respect for the court orders. You have no respect for the judges. You have no respect for the citizens. Therefore, we will not respect your client also. 50,000 rupees cost.
Lordship will call it tomorrow. I will call them, Lord.
No question.
There's only one chance, Lord. Let them rectify this.
Let them improve this. Tell me. Even if Palkiwala comes, it cannot be improved.
No, I'm not improving my case. Yes. I'm saying that if they have committed wrong, let them rectify it.
You have made him to suffer how many years? Since 2012 till 2025, he is before the court.
No, Lord.
What people will think about the judges? Our life is not 500 years.
2016, 2016, the Lordship.
2012.
No. 16, the Lordship said, please to dispose of the application.
We took 4 years for that order. This order should have been made within 5 minutes.
So that,
we are in the habit
that is the system. That is the system.
Techno.
Only simple pay is that.
I'm imposing 50,000 rupees cost because there is no cost jurisprudence in your court. I will develop it.
I can't. Lordship will call it, I will try to get it. Lordship, again I will pray, Lord, so I will rectify, Lord, try to rectify it. Lord, happens, Lord.
Tomorrow you should bring the order.
I will try to get it, Lord. I will try to contact them, say that.
Then today, if I will to dismiss it, allow it with a cost of 50,000, tomorrow if you do not bring, cost will be increased.
That's I cannot.
No, you have to tell to the client. I am making it. So ask him to see the video.
Not so.
Why you are harassing the citizens, I do not understand. You are all harassing the citizens. Supreme Court has said, if one in given set of facts, if relief is granted, other people should not be driven to the court at all. Other people are coming in every case, in one extreme case. I am just going to fix it that date, it will come. They say even reasons will not be given to the litigant. You go to the court and get the reason.
Today,
that is
that should not be there. That should not be there.
This is worse than that.
The here but is appointment or sessions are not regular appointment. That's why I am saying that.
Call tomorrow for further hearing. Yes. Well, you tell your client, I will impose heavy costs. It cannot go like this. We cannot play with the lives of the people. We have a short lifespan. Maximum 70, 80, 90 they will. And if they spend time with judges and lawyers, at least 25% of their life is burnt. At least with courts of this kind, 25% is... Mr. Padi, what I am saying is truth. The governmental institutions are harassing the litigants. My professor Vishwashraya, who was a doctorate from an American university, he used to tell, who was teaching us administrative law, Mr. Dixit, the state is the first enemy of the citizen. When it should, we said, Rajaha Pratyaksha Devataha. Or Smritikara said, Raja, that is like king is the god in England, that way. Here, the king is the first enemy of the subject.
There is a state of slumber.
They kindly see the 2012 case, 2016 the petition is allowed, 2021 writ appeal is dismissed, 2022 May SLP is dismissed, and he has been issued appointment order instead of regular positive direction, regularize him in service. What is this? This is too much, sir. That is the reason they have engaged a strong advocate like you.
No.
That's not. We'll have it tomorrow. Call tomorrow.
No, so may I play one thing? There is another writ application, so connected matter. Both can be taken also, both can be disposed of on the same day.
Another WP.
Right. No, my friend is two similar writ applications.
Which is that writ?
That is not
11683.
11683 of
2024.
2024.
Sir.
Call this. So day after tomorrow we'll have brother.
Sir.
Day after tomorrow we'll have, because he has to have conversation. He has to converse.
118 for 18. Present.
686.
Right. Day after.
Item 48.
Item 48, Madam, I have been instructed to appear in this case along with Mr. G.R. Sethi. May I pay your Smith?
You want time in the
tomorrow or day after?
Tomorrow we have different. This week we have posted already. We'll have it in the first week of December.
May I say coordination matter because
on 24th we'll have that. November 24th. Okay. Next.
Item 49.
Yes.
This is a matter about rehabilitation appointment. Kindly have a glance to page 15, Annexure 1. My lord, the father of the petitioner got regularized with effect from 27.
Your prayer, sister, in this
for rehabilitation appointment, my lord.
The compassionate appointment.
Yes, my lord. My lord, in
father died. What was he?
My lord, he was appointed as common room attendant.
Attendant.
Yes, my lord. He was regularized with effect from 27/11/2004 under Annexure 1, page 15.
Appointed on which date?
Appointed on 16/11/15. Letter was issued with 11/15.
No, you said 27/11/2004.
My lord, regularized with effect from 27/11/2004.
That from date of entry itself.
Yes, my lord. My lord, in the similar type of case, your lordship has already passed an order, my lord.
Yes, please. Now, compassionate appointment. He died on which date?
My lord, he died on 10/3/2010.
You applied for compassionate appointment. Your client is what? Widow or son?
No, son, my lord.
Son.
Yes, my lord.
He applied on?
My lord, applied, my lord, that date is not here, my lord. But the opposite parties have acknowledged their application.
This is the application.
Yes, my lord, at page 23. At page 23. Yes, my lord. That is, subject is appointment under rehabilitation assistance scheme, my lord.
Wi-Fi 2012.
Yes, my lord. My lord, because at that
additional secretary to government saying what?
My lord, that here with the application along with requisite documents, copy of distress certificate.
He sent it to additional secretary?
Yes, my lord. Yes, my lord.
Why?
Register sent.
No, why?
My lord, for consideration of appointment.
Whether university is a department of the government?
No, my lords, the earlier order passed holds good for this case, but only went for my client is that, and your lordship may kindly come to my annexure in the counter, wherein we have sent to the collector, Punjab, as regards rehabilitation as appointment, and to the additional secretary to the government in the Department of Higher Education to seeking permission for his rehabilitation assistance scheme. So that is in short what my...
No, in short, I want to ask you, whether is university a department of the government?
No, it's
a statutory body.
No, it's a statutory body.
But you want to make it a department of the government.
No, it is an autonomous body and a statutory body, definitely.
Correct.
But again, to reiterate my submissions before your lordship earlier made, that the funds
have to come from
the government. So that is the only thing that what I humbly implore upon your lordship to keep in mind. So that
which is that judgment?
Your lordship was talking of Ujambai.
Yeah, Ujambai, no. We have followed Ujambai. I have followed Ujambai and made one judgment. No, what I do not understand is, there is a famous statement by L.K. Advani in his My Country, My Life, a very autobiography. He writes, during emergency, I'm just quoting, I'm not just quoting because of its significance in the
I'm writing down the name of the book also. So that I can
My Life, my Country, My Life.
Advani.
Okay.
He quotes his another book, The People Betrayed. After the fall of Janata government, he wrote one book, People Betrayed. That became part of this book also. There he says, the then Prime Minister, I will not name, asked the press people to kneel down, and they crawled. They were asked only to kneel down, but they crawled. Kneeling down, she wanted, but you started crawling. That your university is doing now. You want to make the university a part of the department of the government, so that the secretary, undersecretary will control the university.
No, in fact, now there's an amendment, but under the 2020 Act, which was tried by the Honorable Supreme Court, the whole thing lied with the government, because appointments, etc., everything was to be done by the OPC, etc. But now things have changed. But in any case, what I have placed before your lordship as regards funds, that's all. Nothing more.
My lord,
As regards that saying of your lordship, that
see, the death happened on 10/3/2010. 15 years are over now.
Yes.
15 years are over now. It only reminds me of the famous statement of Draupadi in Mahabharata, when Lord Krishna said, if you agree for all this, you will become the queen. But for that we agreed for a compromise. She said, already my youth has gone. What I should do with queenship? Similarly, 2010 death happened. Within 1 or 2 years, you could have given the appointment so that the widow and children will not go to the street. That's the object of this scheme. We are in 2025, more than 15 years, and still a compassionate appointment claim is pending. What she should do with the appointments?
My lord, this is my third writ petition. Third writ petition, my lord. And my lord, they have acknowledged my application.
In the first WP, what happened?
My lord,
the petitioner now.
kindly have a glance.
There was the father.
Father was.
No, father.
For regularization.
For rehabilitation.
For regulation.
My lord.
No, for rehabilitation.
Yes, my lord.
I'm asking you, don't get emotional. Because just I'm saying one side, I may find some faults with your.
Yes, my lord. I bowed down, my lord.
Yes, give the first WP.
Yes, my lord. First WPC is 15838 of 2019. To consider my representation.
8 of 2000. It cannot be 2009.
2019. And the order
decided on
11/9/2019. They did not consider my representation. I filed a contempt application. Contempt 1304 of 2022.
2022.
That got disposed of on 3/3/2022.
Instead of saying
That the representation of the petitioner as expeditiously as possible.
so, the contempt court duplicated the writ court order.
Yes.
Correct. Well, this is dated.
Dated, my lord, 3/3/2022. Annexure 8, page 31.
Where they served in the matter?
Yes, my
University
lord.
was served.
Yes, my lord. Thereafter, on page. Yes.
Why are you attempting like that? They were served.
Yes,
Did you take the stand, Mr. Counsel? Did you take the stand before the contempt court? We are at the mercy of the government. Unless the funds come, we will not be able to comply with the order.
That just.
Then how can you treat that point in here?
That part I'm going through the order because I was not the counsel there. So
that makes no sense. Another WP is this one.
Yes, my lord. My lord, thereafter, on 4/5/2022, they disposed of my representation, stating that in the absence of government clearance, the university is unable to take up the case of the petitioner for appointment under rehabilitation assistance scheme.
Whether in first state petition any objection was filed, any counter was filed?
No.
No counter.
No.
In
Only representation to be
contempt?
Contempt also, that is the order, my lord.
No, I'm asking you whether they had filed any counter statement.
No, my lord.
Nothing.
No.
Nothing. Yes, ask your.
And thereafter, they ultimately disposed of my representation, stating that, yes, my lord.
Why do you not make notes at all? Palm notes you don't make?
Yes, my lord.
Such culture in your.
Yes, my lord. My lord, I have.
Where is your palm note?
Yes, my lord.
Use it.
My
Yes.
lord, this is an handwriting. At page 40.
Bigger than writ petition itself.
My lord, thereafter, another writ application was filed bearing writ petition number 26112 of 2022. Court set aside the order dated 4/5/2022 of the university and directed the opposite party number 3 registered to take a final decision on the claim of the petitioner.
4/5?
Yes, my lord.
Order date 4/5?
4/5/2022.
University order.
Yes, my lord. And directed the opposite party number 3, that is the Register Utkal University, to take a final decision on the claim of the petitioner to get the benefit of rehabilitation appointment.
The WC is disposed of on?
That is on, my lord, 4/5/2000. That is on 12/12/2023.
Whether government was a party to any of these petitions?
In all the petitions.
In all the petition, government was.
Then why you did not take up the contention that the government is not making a payment and therefore we are not in a position to? Where is your contention in any of these petitions?
No, probably in that 26.
We do not know probably. Records are with you.
No, 26112. There was a submissions by the senior counsel who appeared in the case.
My lord, that order is at page 37.
That order dated 12/12/2023
is at page 37.
That court set aside that rejection order dated 4/5/22 and set the matter, remitted the matter for fresh consideration.
Yes, my lord.
So that you can be here in the court for all another 25 years. Yes, sir. What is the reason for rejection after the court sent it back? So there is fault on a court also. Endlessly we are remanding the matter as if every remand will serve big justice. It will bring home to big justice. It has not given 1 milligram of justice, getting except the spending time, spending money, and exertion. Nothing has happened. What is your stand? Why you reject it?
No, in that case, what I...
No, that's all right. That is over now, before this court now.
Now, what I submitted before your lordship is that order passed by your lordship in the Muralidhar Swain's case squarely fits into the case of the petitioner. But the only thing that I wanted to point out before your lordship as regards some went
unless you take up such a contention in your pleadings.
No,
how can I direct the government?
There are certain documents which is annexed to the counter.
It makes no sense. Government is a party. You should have taken up a contention. Sir, government is not paying. We are not in a position to do. You do not take up any contention. By your ingenuity, you cannot improve the quality, the content of the stand.
So what I am trying to place before lordship, the government was aware of that.
Unless you tell government is aware, you are aware, everybody is aware of all those.
Aware through these letters.
No, makes no sense. You should have said, unless the government makes the payment, we are not in a position to appoint her.
So that
stand you have not taken.
That part, for particular part has not been taken.
Even here also it is not taken.
No, it is not taken since that I'll not be able to improve upon the case also. That's fairly stating.
What is your stand, Mr. Lenka? Why you are not paying to the university?
I don't know whether the university has made any demand or not. First. Second,
No, all right. Now we are asking. Suppose if the university raises the demand for compassionate appointment, will you comply with that one?
Let the university place the demand. The government will be considered.
No, that is not your stand. Have you taken up any contention that the government has?
At page 36, government has taken this matter, taken up this matter.
Where is that?
At page 36, Annexure 10 series.
This is what this is dated in the earlier writ petition.
Yes, my lord. In writ petition number 2611.
In the last writ.
Yes,
the last writ.
But in that also no objections were filed.
Counter will file, my lord.
Yes, senior counsel appeared
for university. Did you take up the contention? Government is not paying, therefore we are not in a position.
That doesn't find us.
Did you tell it in the order by which you have rejected the claim?
Which one?
And what don't they have rejected?
Only that the father of the petitioner did not hold a substantive post.
Well, order of regulation was there, no?
Yes, my lord.
There was order of regulation on
yes,
that 27/11/2004.
That benefit has been provided with as per orders of this honorable court.
Correct.
But thereafter, as regards rehabilitation, this was the stand of the university that is being
justify the stand.
No, it's just
may I interpret? Page 36. My long sister was showing. Your lordship, I am placing that.
Yes. For approval of your draft objection statement.
I'll let you place it. In inviting, this is addressed to the registrar from the special secretary to government.
Correct.
In inviting reference to the subject mentioned above, I am directed to say that this WPC number so-and-so has been posted and the filing counter affidavit by the state as well as the Upper. Hence, in enclosing here with the application of D. Suresh, son of so-and-so, at another PG has been received for consideration for appointment under RS scheme, it is requested that same may be scrutinized and disposed of at your level on merits.
As per the extent rules assigned.
Yes. The university is the person to take a decision. Now, learn counsel for the university blaming the state government. It is not good.
What do you say, sir?
You didn't take action.
Take decision at your level. Don't send all those things to us.
My lord, they have a letter where they have accepted 24. The register had written a letter to the secretary to consider the case. Now they have improved their stand, stating that the petitioner's father has not been appointed against any substantive post. They have improved.
Take down. Kindly be seated. If I need the statistical data, just give me the dates and other things. Petitioners claim for compassionate appointment by way of rehabilitation, comma, having been rejected by the order dated 4/5/2020, sorry, dated
11/3/2024 under Annexure 12.
2024, comma, this petition has been presented, invoking writ jurisdiction of court. First, learned counsel for the petitioner vehemently argues that the impugned order rejecting the claim for compassionate appointment is fraught with several infirmities, both legal and factual, and therefore the same is liable to be invalidated, and a direction for granting compassionate appointments be issued. First, he takes the court through the checkered history of this case, referring to documents whereof are produced by way of annexures. First, learned counsel appearing for the university resists the petitions on the ground that university has, his client has got a fund crunch, and that any appointment would involve expenditure, unless the state funds the university, comma, there is difficulty in granting relief to the petitioner at its hands. First, learned EGA submits that the university has been informed to take the decision at its own level in accordance with the extant rules, and therefore the stand of the university, the act of the university in trying to pass on the buck to the other is not justified. First, brief fact, next paragraph. Brief facts emerging from the records or as under. Number one, small one. Petitioner's father gained entry to service of the university as boardroom attendant. What?
Common room attendant.
Common room attendant, with effect from 27/11/2004. Person. He secured an order for regularization of his services at the hands of this court in WP number. Regularization order.
A regulation order at page
WP
50.
number.
Hello, that is OJC number.
OJC number
4411 of 97.
441 of 1997. Disposed of on?
Disposed of on. No. That is in compliance to contempt case number arising out of OJC number. That is only written.
Okay. All right. Just look it. This this did not happen. The implementation did not happen, though there was a The first one was not there was no contempt. The regularization was done pursuant to order of the court.
Yes, ma'am.
Thus, services of the petitioner's father came to be regularized with retrospective effect from 27/11/2004. First of all, father died on 10/3/2010, eventually resulting into petitioner claiming compassionate appointment under the extant policy of the university. First of all, nothing was done in the matter, and therefore petitioner filed WPC 15838 of 2019, wherein a coordinate bench of this court, wide order dated 11/9/2019, directed its consideration in a time-bound way. First, this direction was not complied with, and therefore petitioner filed Contract 1304 of 2022, in which a period of 1 month was granted for compliance, wide order dated 3/3/2022. First. Next paragraph. The university wide order dated 4/5/2022 rejected the claim of petitioner for rehabilitation, and that resulted into he filing WP 26112 of 2022, wherein the said rejection came to be voided by another coordinate bench, wide order dated 12/12/2023, and matter was submitted to the portals of the university for first consideration.
That first representation that was before the registered university, they did not reject. They said the university is yet to receive communication from the government. Right, in this regard, after due approval of government, the university will take necessary action regarding his appointment under rehabilitation assistance scheme. Thereafter, I approached.
That is 12/12/2023 order.
4/5/2022.
5/22.
Yes, my lord. Annexure 9. At
the university wide order dated 4/5/2022 said that there was some correspondence happening between itself and the government, and after concrete steps are taken from the side of the government, the claim of the petitioner would be considered. Thereafter, it came to be rejected. 11/3.
Thereafter, on 21/7/2023,
some correspondence took place between the government on the one hand and the university on the other. First of all, the government at long last stated that it is for the university to take the decision as per the extant rules. First. Then the university, having woken up, made the impugned order dated 11/3/2024. Correct. Rejecting.
Thereafter, university did not take any action.
11/3/24.
Yes, my lord. Thereafter, I filed this writ petition 26112 of 2022.
That had set aside 11/3/24.
Yes, my lord.
Now, what is that order? University's
Yes,
order.
my lord. Thereafter, they rejected at page 40.
Page till that
40, annexure 12.
Wide order dated 11/3/2024.
Yes, my lord. 11/3/24.
Rejected the claim on the ground that the deceased father of the petitioner had no lien to the post which he held, because he was only granted regularization pursuant to court order. First, aggrieved thereby, petitioner is knocking at the doors of his. Aggrieved thereby, petitioner is grieving before the court. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one, a brief note on the idea of compassionate appointment.
Annex 10, you Lordship. Annex 10.
What it says?
That the Joint Secretary wrote to all the register of all the university in the state regarding appointment under Odisha Civil Service Rehabilitation. In continuation of this department letter number so, I am directed to say that university employees are governed by the Act and statute of the university, and the universities being the appointing authority may take decision for appointment under RS scheme at their level within the overall framework of rules without referring the matter to the government.
Okay.
That is Annex 10.
Number one, just brief video. One sentence I considered that in that particular paragraph. Brief words, a thumbnail idea of compassionate appointment. Just put that report highlight it, the bit for those next. But doing that, summarize the part. Next point. Admittedly, the services of petitioner father were regularized with effect from 27/11/2004, and thus he was holding the post in question on substantive basis. How so low ever the post may be. First. Therefore, the ground that petitioner could not claim appointment and compassionate basis is militantly untenable, to say the least. First, it is strange that such a contention was not taken up in the earlier rounds of litigation. First time. In fact, as already mentioned above, petitioner's father was before the court at least once for an order seeking, providing for regularization of his services. And he is now dead and gone. First off, his death happened more than 15 years ago. That is on 10/3/2010, to be precise. It is not the case of university nor of the government that the petitioner had not applied for rehabilitation in time. First off, records show that his application was in time. And nothing contrary is stated in the correspondence recorded between the university and the government. First off, university appears to be as callous as the government itself, if not competing with it in showing who is more callous. In a chain of decisions, the apex court said, and at times warned, that applications for a compassionate appointment have to be treated on war footing. However, nowadays the governments, governmental institutions, and the universities show scant respect to the courts and disobey their orders with impunity. That would not augur well to the rule of law, to say the least. Next paragraph. At least as a concession to the shortness of human life, the university and the government should have coordinated with each other and done something to the family of the deceased father of the petitioner by giving compassionate appointment within a reasonable time. First one. Petitioner, as already mentioned above, has been fighting, relentlessly fighting the legal battles one after the other. First one. He has spent valuable portion of his life in the court corridors, which are not happy places for spending. First, this is in addition to the money he spends, family itself being in the distress, financial distress, the breadwinner of the family having gone with the wind. First, less said is better. Next paragraph. Government may be a little justified in telling the university that their rules providing for compassionate appointment are not applicable to case of the petitioner in particular and those of the employees of the university in general. First off, it made it clear to the university, as is pointed out by Mr. Lenkal and Reddy. First off, it is not the case of university that the petitioner is otherwise not eligible for compassionate appointment. And obviously, he is. He is. First off. Neither the university nor the government know the difficulty of a family that suffers financial distress when the sole breadwinner falls to the ground. First off, their hearts do not appear to be at the right places. Right place. Right place. First off, the claim for compassionate appointments are treated sans compassion, as if showing compassion is antithetic to constitutional governance. First off, much is not necessary to specify, and less is insufficient to leave the truth unsaid. First, next paragraph. Learned counsel for the petitioner is more than justified in telling the court that his client should not be sent back to the portal of the university or to the government or of the government for fresh consideration. The only ground for rejection of candidature for compassionate appointment being the wrong premise, namely petitioner's father was not holding the substantive appointment. First, remand after remand would shake the confidence of the litigants in the judicial process. First off, this case has seen too many remands, not even a leaf being turned on the positive side. First, this is a fit case for levying an exemplary course on the university for showing callous attitude to its own employees' children. Full stop. It cannot go. Action of the university, culpable action of the university cannot go with impunity. A reasonable injury needs to be inflicted on it or on its officers, officials. First, next paragraph. In the above circumstance, this petition having been favored, a writ of certiorari issues quashing the impugned order dated 11/3/2024, coupled with a writ of mandamus to the university to issue order of compassionate appointment under the extant rehabilitatory scheme within a period of 3 weeks. 3 weeks. Failing which, and report to the Registrar General compliance, report compliance to the Registrar General of this court. Failing which, every day the university shall pay rupees 1,000 to the petitioner till such order is issued. Next paragraph. The university shall pay a cost of rupees 1 lakh to the petitioner within 30 days. And delay, if brooked, would carry additional sum of rupees 2,000 for the first 30 days and 3,000 for the days next following. First, this cost amount or cost on delay amount may be recovered from the salary of the erring officials personally in accordance with law. Within 3 weeks, appointment order, 1 lakh rupees cost to the litigant, and registry to mark a copy of this order to the principal secretary to the government.
Higher education.
No, principal secretary, the chief secretary to the government. For activating the governmental machinery, so that there shall be no occasion for paying more cost that are imposed, levied now.
Only thing that your lordship, I would like to raise is that part of the cost, if your lordship kindly considers, because in all other cases, which your lordship intended to know.
Generally, I know that this is a poor state. I know that. Statistically going, this is a poor state. I am making a statement now. State is rich, but people are poor. Because the way the constitutional institutions, the government, the university, such other institutions in the state, the work here. I have been observing, seeing the papers. Sorry. I'm sorry. The subjects are not your captive convicts. No. How the government, how the university is taking. Let the government do that. I can understand. Government has many things. I can understand. Why university should be that callous? Your university does not have, I do not know whether it has brains, but I know it has no heart. Your university does not appear to have brains at all because it does not know what will happen if a citizen is treated this way. A little brains would have said, no, courts will be angry. At least court will have conscience. I'm sorry.
What?
No, sir.
Time and again, what I have been advising them is
You advise them to have a heart checkup first.
to comply with your lordship's order.
Brother, I'm very sorry. Pune. See the designation. He's a pune.
I bow down to that.
And Pune came to the court for getting the services regularized. He had to come to court. He died because he cannot, the university does not know that death does not await anybody. One day,
that was regular.
One day, your vice chancellor will be dead, registrar will be dead.
Exactly.
You will be.
Death does not spare anybody.
That understanding they don't have. They think that death will bring some good things to the family of the deceased. No death will bring that. What you have done to the citizens? People have lost faith. They have lost faith in us because consider the representation. One time I can understand. And the second, set aside, remanded for fresh consideration. So that if matter goes in appeal, we are protected. No. We are not ready to take risk at all. Judges are not ready to take risk. They should expose themselves to the abundant risk of their orders being challenged before the higher court. Then justice will happen. If I am afraid, what is that?
No, we cannot be protected unless we get a stay order in that appeal. What? So filing of an appeal does not confer a right on the claim.
It should be. In fact, I would have said that this order should be publicized, so that there are other universities.
Definitely,
they should also know.
Definitely, it should be.
No, you advise your client. No, they will wake up. Don't worry.
No, but the only thing that I would
is cost. Only thing is cost that remains as it is.
No, because
we can't help.
Once.
No, sir, not like that. At least further cost it is there, na? 1,000 rupees per day.
No,
that ask them to save.
No. Since your lordship has adequately deprecated the actions of the university, it's my bounden duty before your lordship to.
Yes, you have discharged that duty very efficiently. Very efficient. I don't dispute, but this is not the way a small man is treated at the hands of the university. Suppose if the registrar were to die,
definitely.
I wish that they should be eternally living. That's another thing. I do not know if others will blame me because I'm wishing that they should live eternally. Such people should not live eternally. They should complete their tenure on the earth as early as possible. Because they don't understand the agony of common man. Agony of common man. I do not know why all these people are like. Only about 1 dozen orders, if they come like this from various courts, everything will be all right.
Everything
becomes correct. I know that. When court state will become rich. Otherwise, all these matters. How much time I have spent for the appointment and compassionate appointment of a son of a pune. But I feel worthy. Time is worthily spent. This court is meant for poor people, downtrodden people, oppressed people, farmers, laborers. Because that's what Mahatma said. You wipe the tears of every eye. Otherwise, constitutional court will lose its meaning. It is not meant for only rich people, powerful people. Rich people, powerful people can get justice. You know how they will get justice also. What about these poor people? Where they should go? Anyway,
that part of which your lordship stated that the contentions were not raised. But in that particular petition, 26112, paragraph 5 states that Mr. P.K. Mahanti, learned senior counsel for the university, does not dispute the stand taken by the opposite party number 1 in its counter, more particularly communication issued under annexure B1 and D1. Probably as regards this.
No, I can't infer all that.
But that was raised.
No, this can be a good ground for appeal also. Yes. I'm not happy. Tell your vice chancellor at the university registrar that High Court is not happy with their performance.
No, that has already been communicated.
And this also will go to them.
Only what I was praying as regards the cost, if your lordship considers.
Consider. Yes.
Item 15.
Yes. Yes, sir.
Yes. My lord, My case for regularization has been rejected after 14 years of my service on the ground that I have passed B.Ed in special education. Your Lordship may kindly see Annexure 8 at page 50.
The order dated 28/2026, even warned or officers do not know the spelling of warning. The son. See this. Warned, what is that? This is
Your Lordship directed for payment of my salary.
August 2025. To whom direction was given?
Your Lordship directed for payment of my salary that has already been paid.
That is paid?
Yes. Now this is for final disposal.
No, you said on 20 August 2025.
Yes.
That the
order was not complied with.
Order was not complied.
And subsequently,
they have complied it.
Yes, they have complied it.
Counsel in the order separate argument. Counsel for the petitioner submits that the order dated 20 August 2025 and 28 January 2025 orders dated have been complied with. And this client has received the salary.
Yes. Your Lordship may...
How many years of service? Date of entry?
Well, date of entry into service as a contractual trained graduate teacher in science, CBJ, on 1/7/2011. Pursuant to an advertisement, I applied for the post of...
Is it covered by the judgment?
Yes, yes. It is covered by Your Lordship judgment of a coordinate bench. My Lord, that I have annexed. Yes, yes. That I have annexed. That is at Annexure 9. A similarly situated teacher whose claim for regularization was rejected on the self-same ground that she has passed special B.Ed. My Lord, that order was passed by Your Lordships and Your Lordship directed for regularization of her service. Annexure 9 at page 68. May I place it?
Yeah. Who pays for the... Mr. Pandit, sir, for whom we are waiting? Sir.
My matter. I'll wait.
Because I spent more time in that matter.
My Lord, Annexure 9 is the order, and that order has already been complied with. And I have given the Annexure 10, Your Lordship may kindly see. Pursuant to that order, they have regularized the services of a similarly situated teacher.
3/4/24.
Yes, 3/4/2024 on completion of 6 years of service.
What do you say, Mr. Lenka?
Yes, sir. We have filed.
Impose cost. Otherwise, many such cases are coming before the court. When they should have been taken, decision should have been taken at your hand.
In this case, we have filed a counter.
Yes, sure.
And we have also dealt the judgment, my Lord Senior, is reliance.
You are also senior only.
He is also senior.
What is the ground you have? On what ground you are resisting the petition?
But Your Lordship may kindly see the rejection order.
Let me...
Annexure 8 at page 66. Page 66. The only ground for rejection of my case is that I have passed B.Ed in special education. Your Lordship may kindly turn to Annexure 8 at page 66.
We have typographed the copy
that the petitioner having
56.
Page 66.
It's not that audible.
Legible.
Not legible.
My Lord.
Not legible.
Because when my services were not regularized, I approached this Honorable Court. And this Honorable Court passed an innocuous order directing for consideration of my representation.
4/8/20.
Yes. Then, my Lord, this order was passed on 18/4/2024.
Correct.
Rejecting my case for regularization on the ground that I have passed B.Ed in special education. Instead of B.Ed in...
having qualified BSc, B.Ed in special education in mental retardation was engaged against
TGT CVJ. Post wide order number such and such.
2011.
That as per advertisement, the applicant has no requisite qualification for the post of TGT CVJ. In view of the above facts, the prayer of the petitioner for regulation of his service has no merit for consideration, hence it is
Show that in
rejected.
the earlier order,
Yes.
the identical point is considered.
Yes, yes. Your Lordship may kindly see Annexure 9.
This annexure, page 66, what is that?
Annexure 9.
8, annexure 8.
Annexure 8 is the rejection order.
Correct.
And this order was passed after your Lordship passed the order for consideration of my representation.
Correct.
And I have been continuing since 1/7/2011, more than 14 years.
No, show that Brother Satapati is.
Yes. My Lord, your Lordship may kindly see para 3. Prayer has been quoted. In that case also, her case was rejected. I am placing.
Trained graduate teacher in arts in terms of resolution dated. No. That was not forthcoming. Para 4.
Yes, para 4. In that case, she was a trained graduate teacher in arts, and so far as the petitioner is concerned, she is a science trained graduate teacher in CBZ.
But if you do not have a qualification also, even then they should recognize.
No, my Lord, I have got the requisite qualification.
Where is the prescription of qualification?
That advertisement you Lordship may kindly see. Annexure 1. Annexure 1 at page 70.
Advertisement dated?
Advertisement dated 20th November 2009. That advertisement was issued for engagement of contract teachers during the session during 2009-10. Eligibility. 2, your Lordship may kindly see 2D.
2D.
D, small d.
C.
Small d.
D.
Yes. As regards eligibility of candidates for engagement of contractual teachers, he/C must have obtained bachelor's degree in arts, science, along with a degree of Bachelor of Education from a recognized university for being considered as trained graduate teacher. So far as my qualification is concerned, I have passed BSc from Utkal University and B.Ed Special Education from MP Bose University. MP Bose Open University. My application was entertained and I participated in the selection process. Thereafter, engagement order was issued. Engagement order was also renewed from time to time. And in the meantime, I have already
D. Bachelor's degree in arts.
As regards eligibility, must have obtained bachelor's degree in arts, science,
along with a degree of Bachelor of Education.
With a degree of Bachelor of Education from a recognized university.
You have that?
I have that. Nowhere it has been specified that Bachelor in Special Education will be excluded. Only Bachelor in Education from a recognized university. So far as the MP
In other words, Bachelor of Education includes Bachelor of Special Education also.
Yes, and that is a judgment of the Delhi High Court. But I have obtained it because Bachelor of Special Education covers both general courses as well as the courses for disabled children. And therefore,
that word special, adjective special will not disqualify you.
Yes.
That's how Delhi High Court said.
Yes.
What was the question before the Delhi High Court?
Well, the same question, whether it is special education covers the B.Ed general degree or not. My Lord, may kindly come. In that case, the Rehabilitation Council of India,
number?
That is page, your Lordship may kindly come to para 4. Before that, your Lordship may kindly see para 3. The Delhi Commission for Protection of Child Rights has filed its response to the aforesaid action taken report in the said response, it has been stated that training provided to teachers during the SCRT orientation is not adequate, and further that there is no cooperation between PWD and DSSIIDC in consideration of infrastructure facilities. In the said response, it has been highlighted that
to next para.
Yes, my lord. The Member Secretary, Rehabilitation Council of India, has filed an affidavit with regard to the special educators to be appointed. The relevant portion of the said affidavit reads as under. Your Lordship may kindly skip over. Your Lordship may kindly come to
one sentence.
Para 12.
One sentence in para 3. Last 3 lines.
Last 3 lines. Yes. I say and submit that a bare perusal of the aforesaid scheme would reveal that.
No, not that. Para 3 last 3 lines.
Para 3.
I don't have page number.
Yes. The said affidavit suggests that in the B.Ed course for the teachers training, special education to deal with disabled children should be incorporated.
It is because of that, perhaps that course is instituted.
Yes. My lord, it is controlled by Rehabilitation Council of India. Rehabilitation Council of India filed an affidavit before the Delhi High Court. My lord, that relevant portion has been quoted. Your Lordship may kindly come to subpara 12. It is submitted that B.Ed Special Education is a degree program for 1 year and minimum qualification for entrance is graduation, and the successful candidates are eligible to impart education to the secondary level of students. Hence, it is equivalent to B.Ed General. Well, Your Lordship may kindly mark it.
Got it.
Diploma in Special Education DSC course is a 2 years regular course. Then the next line has been...
Anyway, then they say it is equivalent course.
Yes, my lord. Thereafter, Your Lordship may kindly see the
next 3 lines.
Without prejudice, I further say and submit that successful candidates of B.Ed Special Education in broader aspects are much more trained in comparison to the B.Ed General and B.Ed General, because apart of training of teaching under this course, they are getting the training to how to teach physically challenged children. Therefore, these candidates should get priority to be appointed as teachers in schools, as they can teach general as well as children with special needs. That is the affidavit of the Rehabilitation Council of India. Then NCERT affidavit was also reflected in para 5. National Council for Educational Research and Training, hereinafter referred to as NCERT, has also filed a brief note with regard to employment of special educators, public counselors in the school.
Go to now, para 14 you left.
Para 14. Para 14 of that, yes. I further say and submit that a council is a statutory body to regulate the training program in the field of disability. Section 13, subclauses 2B of the Act provides that no person other than qualified and registered with council can teach children with disability. In some of the state government has already considered the equivalence B.Ed, special education with B.Ed General, and D.Ed special education with D.Ed public TTC for the purpose of appointment of the special teachers in all the special schools as well as integrated schools in the state. And here, well, the petitioner has not misrepresented the authorities nor committed any fraud. He produced that certificate, he was selected, and after 13 years, now the rejection order has been issued to him saying that since he has acquired special education in B.Ed, he is not eligible.
Yes. Mr. Lekha, what do you say?
Yes, sir. And we have filed a counter, Your Lordship. My learned friend has shown the advertisement.
Yes.
That requirement.
But you only appointed him.
Yes, madam.
After advertisement, after seeing all the records, you appointed him.
Yes, on contractual basis.
Correct.
On contractual basis.
Correct. So you can't say and he did not have any qualification for contractual appointment.
No, we have done. We have appointed.
After seeing all the papers.
Yes.
There is no fraud, misrepresentation from his side.
No, we have also not said that in any problem.
There is no complaint all these years.
Yes.
Against his performance. There is not even a whisper in your objection.
Yes, that way. But your lordship will the advertisement was for the eligibility criteria as per the advertisement was BA, Bachelor of Arts, and BEd. And their appointment was for the post of junior teacher.
No, not junior.
TGT, trained graduate teacher.
Science.
To taught the students chemistry, biology, and zoology. CBT, the post is very much.
Chemistry, botany, and zoology.
Chemistry, botany, and
CBJ.
That is there.
I'm super.
Admittedly, what my learned friend has stated before also, he has acquired a BEd with a special qualification for the mentally retarded children, even blind children, as a special education. But here, in the schools, in the TGT post, no such students are there. No such students are there.
Then why you wanted BEd?
Bachelor of Education.
Bachelor of Education includes special education also. They are taught education. In addition to that, the focal point will be on the special education. It is not your case that the candidate who has obtained BEd with special education will not have the subject knowledge which a candidate of BEd general will have.
Admittedly, there was no advertisement for BEd special education.
No, but you have appointed. That
we have appointed.
Available to you now.
We have appointed.
Then you have to go from there further now. He has crossed the bridge now.
Yes, we have appointed and on contract basis and for certain period his engagement was not renewed and by virtue, yes, please, by virtue of the...
During what period it was not renewed? But that is not the ground you have stated in the rejection order.
No, but in the objection we have placed.
No, that makes no sense. The order of the authority has to be adjudged. Its validity should be adjudged on the grounds contained in its womb. You cannot put something in the womb of that order. What is there is there. What is not there is not there.
You actually order is the rejection order is that he does not possess the qualification.
All other things are irrelevant to us.
Yes, that is there. That is there.
Mohindra Singh Gill.
Yes.
78 Supreme Court 851.
And one thing has been said in that order, rejection order, that he does not possess the requisite qualification in terms of the advertisement. That is there.
That's the only ground.
No, yes.
Other grounds are also there. No.
Yes, I'm going well. Can you can see the qualification prescribed, paragraph 15 of my counter. Your Lordship, kind of. Your Lordship, kindly come to paragraph 9. Paragraph 9, page 5 of my counter.
Yes. What is that?
It is actually submitted that also the advertisement for the year 2009-10 for the engagement contract teacher in government high schools, the eligibility criteria TGT Arts Science for a post as follows. As regards eligibility of conditions for the engagement of contractual teacher, she must have obtained bachelor's degree in Arts Science along with a degree of bachelor's of education from a recognized university for being considered for the 10th graduate teacher. Then your Lordship can come page paragraph 11. In the middle, in this context,
Your Lordship got.
I got that. You only say it did not have qualification, but how that question does not arise at this length of time?
Now, and one thing, he submitted, he only placed at the time of selection, he submitted the mark list. And after selection and engagement, he submitted the certificate.
You should have dismissed him. At that time only, should not have appointed at all.
In page 7, that has been, we have stated.
No, that is not the ground. You have to confine your defense to the reasons given in the impugned order. You cannot go on improving. Justice Krishna here mentioned it so beautifully. There are two judgments. One is the Commissioner of Police, Bombay versus Govardhan Das Bhanje, AR 52, Supreme Court, page 16. And Mohindra Singh Gill versus Chief Election Commissioner, AR 78, Supreme Court, 851.
Yes. Yes.
Justice Krishna here, he said, an order of the government is not like a wine. It does not become better as the time passes. You cannot furnish the reasons, divorce the order by way of affidavit, counter, objections, etc. Very metaphorically, he has phrased that paragraph. Do you have that paragraph? Anybody?
Mohindra Singh,
that paragraph. 31. It tempts anyone to read.
Yes, yes.
Go to that.
Then this certificate he produced after he got the engagement.
Why did you select him?
The selection, at the time of selection, only mark list he has produced.
No, you appointed him. Why did you appoint him? You can't go back to Alexander's time saying that BC 323, Alexander should not have come to India this way. He came, he went back, he died on the way. That makes no difference.
That is paragraph 8.
Then paragraph
8.
MS Gill.
MS Gill. Read, kindly read it.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, gets validated by additional grounds later brought out.
No, there is a metaphor. Wine, etc.
Yes. We may here draw attention to the observations of Bose J. in Coram Bhanji AIT 1952 Supreme Court. Public orders publicly met in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or of what in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to effect the acting and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine, becoming better as they grow older.
So beautifully, judgment. Justice Krishna used to write so beautiful judgments. That Ratnam municipality, EWSSP versus Raja.
And even if in Bhagwati Prasad case, Your Lordship may kindly see, the Supreme Court has already held that if one does not have requisite qualification, but that is my extreme argument. If he has continued for a long period,
that itself becomes
yes, paragraph 6. The main controversy centers around the question whether some petitioners are possessed of the requisite qualification to hold the post so as to entitle them to be confirmed in the respective post held by them. The indisputable facts are that the petitioners were appointed between the period 83 and 86, and ever since they have been working and have gained sufficient experience in actual discharge of duties attached to the post held by them. Practical experience would always aid the person to effectively discharge the duties and is a sure guide to assess the suitability. The initial minimum educational qualification prescribed for the different post is undoubtedly a factor to be reckoned with, but it is so at the time of initial entry into the service. Once the appointments were made as deliberated workers and they were allowed to work for a considerable length of time, it would be hard and harsh to deny them the confirmation in the respective post on the ground that they lack the prescribed educational qualification.
This answer. Yes, only that much. Take up.
And so far the coordinate bench judgment, my friend has relied, we have explained in paragraph 8 our counter.
We need not go to that. We will reject his contention founded on that coordinate bench judgment. What about this? Two grounds. One is we have taken the specific ground X. Whether X is valid or not is our focal point. All other things that come after the marriage, pregnancy, and delivery, they are irrelevant to the validity of marriage.
And yes, it's continuing last 14 years, it is admitted that.
Take up. Yes. Petitioner who has suffered order dated 18/4/2024 at the hands of Director Secondary Education, at Annexure 8. Annexure 8. Yes, Annexure 8. He is knocking at the doors of Brit Court, seeking its invalidation and for a direction for regularization of his or her his service. Learned counsel for the petitioner submits that the only ground in the impugned order for denying regularization is that his client lacks the educational qualification. First, he adds that the educational qualification prescribed in the call advertisement at Annexure 1 prescribes which the petitioner has acquired, and therefore, on that sole ground alone, petition to be allowed. First. Secondly, he presses into service the Delhi High Court judgment in WPC 677 of 2008, decided on 16/9/2009, to the effect that a degree in special education is equal to a degree in general education. That is, BA into brackets AC approximates to BA into brackets general. Thirdly, he presses into service a decision of the Apex Court in Bhagavati Prasad versus Delhi State Mineral Development. You don't have a citation of this, Mr. Sir?
Yes.
It is here. AR 1990,
page 37.
SC 371. To the effect that once, in terms of prescribed qualifications, a candidate is appointed in due selection process, it is not open to the appointing authority to contend that he lacked educational qualification for the purpose of other service benefits like regularization, etc. Especially when his services have been drawn for a long period after irregular income. Person. Next one. Learned AGA Mr. Lenka, drawing attention of the court to the objections to the counter, vehemently argues that the qualification acquired by the petitioner does not answer. It's a description as made in the advertisement at Annexure 1. 7. In the absence of requisite qualification, nobody can claim appointment, much less the regularization. 7. Education goes to root of the matter when recruitment process is undertaken and therefore cannot be ignored. So he also loudly reads out certain other contentions that have been taken up in his pleadings for assisting the petition. First, next paragraph. Having heard learned counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number 1. Petitioner came to be appointed
1/7/2011.
October 6th. Came to be appointed, gained entry to the position in question with effect from 1/7/2011. 7. The selection process was undertaken in terms of the advertisement dated
20th November 2009.
2009 at Annexure 1. Correct?
Yes.
Yes.
Annexure 1. Class D.
My lord.
Class D, you were reading.
Clause
D under the educational column reads as under first. After seeing that 2D, clause 2D, that will be, which reads as under next one, below that. After examining the documents, the selecting body came to the conclusion that the petitioner was qualified for the appointment. Third, accordingly, select list was prepared, followed by the appointment order. First off, since then, years have lapsed, and there is absolutely no complaint whatsoever about the quantitative and qualitative discharge of duties of the petitioner all through. Yeah. Therefore, the contention of Mr. Lenka that the petitioner lacks requisite educational qualification is liable to be rejected, to say the least. Next paragraph. Learned counsel appearing for the petitioner is more than justified in contending that the qualification which the client does possess answers the requirement of the advertisement in as much as advertisement semicolon. He is right in placing reliance on the Delhi High Court judgment, which is structured on the basis of the affidavit filed by the member secretary of Rehabilitation Council of India, wherein paragraph 12 reads, 12 and 14 read as an. First, therefore, the contention as to the requisite qualification as taken up by the petitioner is adumbrated. Next paragraph. Learned counsel for the petitioner is again justified in placing heavy reliance on the decision of the apex court in Bhagavati Prasad Supra, in contending that once appointment takes place on a regular basis and the appointee works for a long period with no complaints whatsoever, whatever arguable defect in the educational qualification would fail into insignificance. First, at para 6, the apex court has observed as and as, and that comes to the aid of the petitioner and demolishes the stand taken by the respondent. Next paragraph. Mr. Lenka very passionately resisted the petition, taking up various contentions that are alien to the reasoning of the impugned order. First, the apex court in Govardhana Das Bhanje versus Commissioner of Greater Bombay, something that year 1952 Supreme Court Commissioner. That paragraph, you said with that paragraph, paragraph why etc. I said
Mahendra Singh Gill.
No, that is Gill, but that is taken from Govardhana Das Bhanje.
Bhanje, that is
52 Supreme Court page 16.
Yes.
Tell me the paragraph.
Yes. Paragraph.
Govardhan Singh Bhanje. Just fill out that paragraph, not by the time pass, etc. Up to that particular point. In the evening, the word wine fills anybody.
That is 1952 Supreme Court, page 16.
Correct.
Paragraph 8. In paragraph 8, it has been reflected. That has been quoted. In Mahendra Singh Gill's case, that has been quoted.
Therefore, contentions alien to the reasoning in the impugned order have to stay away in the adjudicatory process. First time, in the above circumstances, this petition is allowed and the writ of certiorari issues quashing the impugned order, coupled with the writ of mandamus to OP number.
That is OP number.
Sit and answer. It was seniors to me.
OP number 3.
OP number 3. To grant regularization
on completion of 6 years. That is their scheme.
With the effect from the day on which the petitioner completed 6 years of regular continuous service. Yes. Service. And further to grant all consequential benefits within a period of 3 months.
Yes.
Paragraph 9. Paragraph 9.
Thoughts reluctantly made easy.
Paragraph 9.
Yes, sir.
Paragraph 9.
Mr. Lenka, anyway, I am not involved in this matter. But we have to develop the cost jurisprudence. Otherwise, there will be no accountability for your officer. They will say, We make wrong order, we don't care for the government advocate to justify. And we will very effectively justify. But there is a limit for justifying the orders also. So we will develop cost jurisprudence. You all should cooperate with me. We will impose costs which you may recover from the hearing officials of the government who has passed the order.
Yes.
Okay?
That is Govardhan Bhanji case, paragraph 9.
Paragraph 9. Yes, paragraph 9. Okay. Just structures. It's very good in structuring the after I give that he prepares fully. Yes.
May I please, Your Honor?
Yes.
Like it's a removal from service of a primary school teacher.
Removed from service?
Yes. The facts, my lord, I'll just say only one.
I'm not very sure that others will be able to get any orders today. Because few matters I'll take only 15 minutes. I'm sorry if I have held you up here.
No, within 15 minutes I can get my.
I'll go on with your matter. No, I'm just saying they have an option to go back to home. They need not wait here. Yeah.
Next matter is 9, branch of matters.
Then you be here. I will take up that matter. When you find this matter, any other.
In this any time in this month, a little higher up in the list, then I don't try.
Which year matter?
Matter is of 2024. What about the liability of a COVID hospital from the government? COVID hospital has started. Any time of this month, the little higher up in the list.
This month we have a bit difficult.
Yes,
we can take up this matter on 11th of November. 11th of November.
This month I meant November. No, not October.
Very.
11th November.
You are very kind to me.
Only by prayer, Lord. Little higher up in the list. I don't know whichever manner.
But it is difficult because the computer will not accept.
Yes.
I tried all that.
If you also direct PM or 3:30 or something, keep possible. Get
that 2 key.
Grateful.
That matter.
Grateful.
I completely. No, instead, you should sit in the court to teach the judge.
Annexure 15, my lord, is the order of removal.
Annexure 15?
My lord, page 99.
On what ground you are removed?
Well, removal is, my lord, if you actually look at that order, I have said because my authority directed, I will remove him from service. And authority passed the. This is a case, my lord. 1996, there was a selection.
1996?
Yes. I have given us written note, my lord, with dates. If you actually can see that, please.
Written note is there.
Cost is there. That's there.
It's 1 lakh rupees. That for that sentence. So, yes.
But there was a selection made in 1996.
Selection advertisement dated?
Yes, advertisement that was made 12/3/1996.
Advertisement?
Yes, that selection was made, but
no, answering the point. Date of advertisement.
Date of advertisement, my lord, was not there because it was a sponsor. And the government says by virtue of this, the candidate being sponsored by the employment exchange, there will be a selection.
It is a e-sponsorship.
Yes. That government resolution was 12/3/1996. This is, my lord, regarding primary school teachers of Jagatsinghpur district.
What the notification says?
The selection was to be made by primary school teachers, my lord, as per the requirement. And the selection was challenged. Ultimately, my lord, 17/11/2006 appointment order was issued. After 3-4 original applications were disposed of, 17/11/2006 appointment was made.
17/11/2006.
Then that was thereafter further challenge was made in original applications were made in 2015 of 2008.
Further challenge to
appointments
by others.
Yes, and ultimately, my lord, I was issued the so-called notice in 2017. 10/3/2017. The details are given, my lord, that written note I have given.
Give that note sheet. We don't prepare farm sheet.
Yes, it is only
farm. Yes. Palm leaves, have you heard of?
Yes. Only one page.
Patra.
Only one page.
One page. Yes.
That 10th, can you come to page 3 of that note? 10/3/2017, my lord, I issued with a so-called notice by the opposite part number 3 that the saying that why your services shall not be terminated because your name is not found in the recast reselect list. First, my lord, there is a select list.
That select list was dated?
Select list. That is 2/12/2004.
2/12/2004.
That was the initial select list was 24/1/2001.
24/1/2001.
Thereafter, as per the direction of the tribunal, it was recast. That was, my lord, revised list was issued on 2/12/2004.
That show cause notice was issued to you when?
That was, appointment was made thereafter in 17/11/2006 after the list was revised further by the government.
In that list, your name is found?
Yes, sir. And based on that, my lord, 17/11/2006, I was appointed.
So your name is the select list?
Yes, sir. Just see.
I can, good in service law is my impression. I don't know. I may be wrong also. Just give me your, show your name in the select list. Because they said your name does not appear in the select list.
No, subsequently, my lord, notice was issued saying that the list pursuant to which you were appointed got further revised by the government.
In that, your name is not found.
My name is not there.
That list is dated?
That list is dated, my lord, 17/11/2006.
That is appointment, na?
2017, my 2006, my appointment. This was, my lord,
17/11/2006, you said already.
Yes.
That is date of your appointment.
17/11/2006. Yes.
What is the subsequent list which they are referring to?
They are referring to, my lord, that is, the date is not, my lord, in my
You are
list.
not mentioned in that one.
No, I'm not this, but I have said, my lord, that next year 6.
8/3/2017.
8/3/2017. That list.
Yes, after the direction of the tribunal and this honorable court, a recast was made, and that list is.
Now, whether the tribunal permitted sending all these people home?
No.
Then how can you send him back now?
After recast, when his name didn't found place, then you are so-cast and opportunity was given and.
Next year 6, when I issued the so-called notice.
How many such people are there?
So, your Lordship may kindly, I have no notes here. What happened, my lord? On 12/3/1996, a select list of teachers was published.
That was challenged, matter went to court.
Some person challenged because they said before the tribunal that we have secured more marks and this person have secured less marks and he has been appointed. So thereafter, on 1/5/2010.
No, even if I agree with you, I want to know.
Yes, sir.
How many such cases are there? How many vacancies are available? I am here to do justice. I am not a butcher. I am a surgeon.
They were around your Lordship.
They were. As on today, matter is taken up today. As on this date, at least as on the date the petition is filed, or at least on the date you have filed the statement of objection, how many vacancies are still available? Because somebody has died, somebody has resigned, somebody is removed. How many vacancies are now available?
Your Lordship's query is answered in paragraph in page 13 of my counter.
1-3.
Yes.
Go to the counter.
Paragraph 18.
Paragraph 13.
Yes. Page 13. Paragraph 18.
Paragraph 18.
Yes. The status as on 20th July 2023. Number of candidates continuing now 99.
99.
Yes. Number of candidates
retired 18.
Number of candidates died.
1.
Yes.
Number of candidates transferred to Cuttack for
Cuttack part. The service was total number.
1 second.
Yes.
11 plus 1, 12 plus 18, 30. So 30 vacancies are available. Now it must be more.
Yes.
Because this was in 2023.
Yes.
How many vacancies are available? I can't send them home that way. What is their fault? And after how many years? 17/11/2006. 19 years now. Any interim order is granted to you?
Yes, initially interim order was there.
All are.
I was continuing, my lord.
You are continuing?
Yes. No, by annexure 14, my lord, immediately there was a termination.
Now that
This honorable court, my lord, permitted me to file a show cause. I have filed a show cause.
After the termination order was quashed by this honorable court, and this honorable court directed to give him opportunity.
Correct.
So cause notice was given, and he was called, and thereafter the final termination order.
No, you tell us how many vacancies are available. You can't send people because people after gaining employment in the government or governmental body, they go for marriage, they decide size of the family, they go build the house, they borrow the money from the bank. A series of things happen. We cannot just quote some rule and send them back like that. That is not the object of writ jurisdiction.
Like petitioner, there are 10 such people.
We want to know how many people are there, whether they can be accommodated in the
That instruction I have to take. I have to take. Paragraph 17, we have given 10 such people are there.
The OPs to update the information as on this day for what has been furnished in paragraph 18 of the counter. You update it.
Yes.
Update it. Okay?
Yes.
As on the next date of hearing. On the next date of hearing. Failing with an adverse inference favorable to the petitioner may be drawn against the OPs. Yes. Which date you want? I'll give you.
Well, actually give 3 weeks time.
3 for this information. It is by a telephone you can
because Jagatsinghpur DO under
but telephone even if you speak to Moonlight, the same one.
And your lordship has to pass another order.
Of this matter. On 19 we will have Mr. Lenka.
19th November.
Jagatsinghpur district.
Oh. Information
because it is district wise.
District wise appointment.
Yes.
No? Therefore, so far as Jagat Singh district is concerned.
Jagatsinghpur.
Sorry to disturb your lordship. From 11th is a prefix matter. Your lordship may place 12, 13 any time, but not 11.
All right. On 13th we
That's great.
13th. That would be 6 matters. 6. Add to 12. 12 also. Yes. Yes. Yes, sir.
This item, the batch of cases are here. The batch of cases. The dispute is this. These petitioner as an in-service candidates from 2007.
Only today yesterday we have filed the counter.
Yesterday.
This case. And that is not in your lordship's.
No, you get it now.
Just
ask them to bring the counter.
Then
say another ground.
No, only that.
So this is the from 2017 to 2019 that NCTs
make a statement.
Yes, sir.
Of the case within 2 sentences.
Yes, I know that. Yeah. So what has happened? The dispute is whether the diploma in 18 months can be treated to be a qualification in terms of the advertisement and so far the NCT's directive is concerned. Now what has happened?
No, but it's a prescription.
The prescription as per the advertisement.
I have also prepared a note.
Yes, sir. Prescription as per the advertisement is yes, eligibility criteria is this. 2 years diploma in elementary.
2-year diploma in elementary
That is
education.
exactly the point, sir. The advertisement was made on 10/9/2023 and the last date was 10/10/2023.
Right.
Way back in 2021, NCT, on the basis of a judgment of a Patna High Court, issued a circular, because all of it, just 1 minute, it's a circular where they say, naturally, the 18 months qualification, 18 months acquisition of this diploma should be treated as a valid diploma in DLET. That is what in 2021, on the basis of a judgment of the Patna High Court. That matter was carried to the Supreme Court in by different states candidates, and ultimately Supreme Court said it is not equivalent. So for this,
because course duration is prescribed by the employer himself.
Yes.
This is the requirement of the court.
But subsequently, in a review application, the Honorable Supreme Court said that for one time, there should be this 18 months acquisition of this diploma course must be
equated, approximated.
Only for the session from 2017 to 19. That will also carry
that particular
year. That is
you fall into that particular.
We are falling on that particular category here. Now what has happened? Subsequently, another order was passed at the instance of various cases, including the state of Orissa and so on, that and arising out of the same advertisement and same procedure of that eligibility criteria. One matter, that is WPC number 13835 of 2025. There was some defect, and that was listed before your lordships. And on 19/8/2025, your lordship allowed time for removal of the defects. But in the meantime, the matter was transferred to the Supreme Court. Very same prayer, exactly the prayer which was made in the present writ application. It was transferred to the Honorable Apex Court, and the Honorable Apex Court has passed this judgment to give them appointment on the basis of the yes.
Is it?
That's it. Case.
Whether Mr. Lenka, did you see the objection? That I'm asking.
Yes, that is exactly the question.
Whether you have structured your statement of objection, whether the counter, after seeing the judgment or before seeing the judgment.
I had given a copy of the judgment, but he has not answered that.
By an amendment, by an amendment, filed that judgment of Uttarakhand High Court. Yes, Supreme Court. Yes, madam. Supreme Court judgment. Jaivir Singh case. And we have, on the basis of that, we have filed the.
But thereafter, Adarsh Kumar Srivastava versus State of Uttar Pradesh. Yes. The judgment has come.
And also look to that judgment. So from the state of Orissa is concerned.
Orissa is also there.
Yes, sir.
Same advertisement.
Same advertisement.
Our stand is the judgment is not applicable in the present case.
Sir,
just we wanted
because the Honorable Supreme Court has categorically said that it will be given effect from the date of judgment in the clarification made in the review application. But here, the selection has been done much before the judgment passed by the Honorable Supreme Court.
That's why look to the TPC number 1052 and 1404 to 1406 of 2025. This court in the case of Jaivir Singh and others versus state of Uttarakhand and others. This case, so far the state of Orissa is concerned, TP case number.
Diploma orders for the purpose of applying in other institutions or for promotional.
Yes.
What is other institutions?
Now you also look to paragraph 5. The respondent states are directed to issue appointment to the petitioner within a period of 3 months from today. That is the last order which was passed on 8/10/2025.
No, I want to know. Kindly read. Candidates who were in employment as on 10/8/2017.
Yes.
Yes, sir. Yes.
And who had completed the diploma 18 months would be treated as valid diploma holders.
Sir, we have.
In employment?
Yes, sir.
You are in employment?
Yes, sir. So we have satisfied that requirement from 2007.
Para 1 and 5 to be read together. No? That's your message.
Yes. If your lordship
like that, just look into that.
No. Your lordship ordered at a 28/25 order. In this case, order number 7.
Order number 7.
This Honorable Court had already asked this question and we have given the affidavit.
the other judge.
Yes, Justice Shatpathy.
That was the subject matter. Because the Honorable Supreme Court clarified they should be in employment as on 10/8/17.
You'll have it tomorrow? That's the only point now.
No, that is not so easy.
You see?
Not in, I pray, the argument should not be in a piecemeal basis. Let it be from the foundation.
Tomorrow.
Because there are many points will be
considered.
Yes. Where Supreme Court, Honorable Supreme Court has kept in paragraph 36 of the judgment has said, Your Lordship,
may I then, if my Lordship wants some other day, Your Lordship call for that records which has been transferred. That is the WPC number, DWPC number 13835 of 2025.
No, how long they have been transferred to Apex Court? Okay.
But the record is very much available. Your Lordship's order is much available. That can be. We have produced the order of the Apex Court. 19 persons were there, petitioners. Same advertisement. Same prayer.
Yes. The registry to put up the file of WP number?
DWP number 13835 of 2025.
Which date will be?
DWP 6
on 12th, only the 9 matters. 6 matters. On 12th we'll have?
Yes, sir.
Yes. No problem. You give that judgment also. The review judgment you don't have.
Yes, sir. I had already given.
Record.
Yes, sir.
One matter, item 53. It's a old pension, applicability of old pension rule matter in respect of the petitioners. And the case has been already decided by this Honorable Court or upheld by the schools.
My Lord,
Any date may not stop date.
my Lord, item number 67, my Lord.
I haven't made any order on this submission. I'm not to do now. But November 12. How many matters on social? Check that. 8. That much. Yeah, brother, you were saying something.
Item number 67, my Lord.
67.
Your Lordship has fixed the date for hearing on today, but
no,
I pray before Lordship the date may kindly be fixed.
You put that also on the top.
Only a case for this special lordship. Who are interested because of his wife is petitioner of their lordship. And stage operating, they're not getting lordship appointment. Can it be time may be fixed lordship so that it can be because opposite party are there?
See, now on that day you just mentioned lordship.
Can your Lordship, with your permission?
Yes.
On 12 your Lordship fix this matter. At 2 o'clock, can your Lordship?
2 o'clock already we have fixed the matter now.
That other matters.
Parties matter we have fixed. It appears to be heavy matter. That's very good. 13th
many matters.
21 matters.
Yes, in my matter, intermediate.
Let them come at least, yes, so that we start that way.
In my matter, intermediate.
I don't see that there is going to be any major change in the near.
I hope so.
We also hope so. My Lord, item number 67, interim order may kindly be extended. Interim order.
Today's rest of items may be extended. Matter today may be taken tomorrow.
Why? Oh, brother. So many matters. Yeah, put just to see all dates should be after 17. All right, just see them according to.
Yes. Deeply obliged.
Of course.
Deeply.